really, every time I go to one of these panels, I am so inspired by the women and beginning to end their journeys. And not just those who, are in research labs, but the creative arts as well, intellectual property as a whole, how to take advantage of it. And sharing that knowledge with other entrepreneurs is very, very inspiring. Another program that we run is within other IPOs around the world. So I've had the great opportunity of working through inclusive innovation, which is really nationally focused. And as I was going through my work on the side, the international side, I just had that light bulb moment, like, think big, Valencia, think big, right? This isn't just for our nation. For our nation to be the best that it can possibly be, we have to go global. So one of the things that started through my staff was meeting every month with other IPOs to develop different ideas, to develop and share data on their particular IPO as well as their applicants within that go through their organization, and focus on what can we do to build more inventors, more women within the IPOs, as well as moving up the ladder. So we've had two so far in 2023 and in 2024, Women in IP Symposium, where I was really excited by the number of organizations. I think we had about 45 countries that participated. They came to the USPTO and about 100 people, as well as a series of about 60 panelists who spoke on empowering women in the space of innovation. And I will go quickly, I promise, with the mentoring, which we've had a lot of really great presentations so far about the need, the value of mentoring. Through the Women's Symposium, we actually developed a global mentoring program where 13 other IPOs participated. It's been very successful so far, but we're going through data analysis. So next time I speak to you, I'll have more information on that. As well as mentoring that we have through the Women's Entrepreneurship Program, where the USPTO has partnered with both IPO as well as AIPLA to find mentors for participants in that program who would like to be mentored through entrepreneurship. And the third that we have is through one of our affinity groups at the USPTO, the National Society of Black Engineers, who's established program called Sankofa, where they don't call it mentoring, they call it partnering, where you have the mentor and the mentee who are training and teaching each other through whatever it is, personal, career, performance issues that they really would like to address. And really what I'd like you to get out of that, these three different programs, is the collaboration. You can do it alone, but why do it alone if you don't have to? It's so much better, stronger network, stronger delivery, stronger successes when you collaborate with other members of the community. So I will stop there because I know I've gone far too long, but I will be here for any questions you may have, and thank you so much.
Thank you, Valencia. And it's really exciting to hear about all the PTO initiatives that have been started, have been going, and also the commitment to evaluation and really trying to figure out what's worked and how to build upon that. We're a little short on time, so I'm just going to invite our speakers. I've certainly felt a lot of reasons for optimism, but as a sort of final reflection, to ask them each to provide either what's kept you going, what's made you optimistic during this period in terms of the research, or to discuss what you think are important next steps that we as a community, sort of working collaboratively, should and should take to advance this agenda. So I'm gonna start with Holly, because I know that she has some specific things that she's been working on, and then invite each person to chime in on this question.
Thanks so much, Kelly. So one of the things I mentioned before, we work on public policy. and have passed 3 different bills, and happy to talk more about that. One I think is particularly relevant to this audience because it's called Unleashing American Innovators Act, and it did many things like help improve the pro bono program, but it also created the Southeastern US PTO office, which is very exciting that it's here. But the current public policy initiative that we're working on is the Senate Judiciary Committee is going to be voting next week on a bill called the IDEA Act. And what this bill does is direct the USPTO to collect demographic data on patent applicants on an entirely voluntary basis, and that information would be kept separate and confidential from any decision about granting a patent. But why is this important? This is important because we don't have this information now. I give a huge shout out to the researchers who have used name matching software to come up with the numbers that we do have. For example, the fact that there are less than 13% of inventors on patent now are women. But that is done not because we actually know the information, but because the researchers are using this. Well, that may work well for gender. It doesn't work at all for example, people with disabilities. So we want to have the USPTO work to collect this information so that we can make more progress. We can identify the gaps and we can work at solutions to solve them. So just to let you know, this is going to be voted on next Thursday. It actually already passed the Senate. There was a vote on the Senate floor on this bill as part of the CHIPS and Science Act, and it passed on a strong bipartisan vote with 71 votes. It even passed in the House, but the way our system works, it didn't pass in the House and Senate on the same bill, so it is not yet law. So we are really excited and looking forward to trying to make further progress on this issue.
Great. Any others as well with your reflections or reasons for optimism?
Yeah, I'll just say one thing. As a finance professor, very interested in kind of the corporate setting. And one thing that's becoming more common is shareholders of publicly traded companies are increasingly interested in how employees are being treated within firms. And this has led to new disclosures, companies having to disclose how they're treating employees, how they're attracting employees, how they're retaining employees. And so that's going to lead to a lot more opportunities for additional research as we get better insight into how some of the largest companies in the world are taking care of their workers.
Great. And Valencia, I'm going to let you have the last word.
Thank you so much, Colleen. And so I'm going to say what started me in this work and what keeps me in this work. I'm going. Some of you may have already heard, but it's my own journey from being an African American girl in the Deep South who had parents who told us our worth, my sister and I, from the very beginning, and didn't let anything stop in our way. And the people who saw something in me along the way that wouldn't let me ever stop. Please go back into your careers, into your local communities, because I know they exist. I am one, not the only one, but one of very few who have had a really rich, successful career because other people saw more than just a Black girl.
With that, thank you so much to our panelists, and thank you all for participating in the session. We are going to take, I think, just a little break. Go ahead and grab some coffee, and we'll be back in just a few minutes to talk about practical insights from the Diversity Pledge. So maybe we take like about 5 minutes, and we'll see you all back here for that conversation. Thank you.
Testing, testing. Sabra, can you say something?
Hi, everyone.
All good.
How are you?
All right, if you can please take your seats, we're going to get going with our next panel. So please sit down. You won't want to miss this. Please go ahead and take your seats. Great, you guys ready to go? Okay. Excellent. Just come on in. We're going to keep the program chugging along, and we're going to switch gears. We sort of talk a lot about research and about insights from doing diversity pilots and also some of the different projects that the PTO is pursuing to now really talking about the companies themselves and the great work of the Diversity Pledge that's been going on for several years. Again, the Diversity Pilots Initiative in some ways developed as an adjunct to support the Diversity Pledge and sort of the committed work of patent attorneys, practitioners, counsel within companies to really move forward the needle within their organization. So I'm going to turn it over to Suzanne Harrison, who is the co-founder of the Pledge, to talk on a panel of folks about what they've been doing and what they've learned, these practical insights that you won't want to miss. Go ahead.
Great. Thanks, Colleen. I really appreciate it. So my name is Suzanne Harrison, and I have a management consulting firm called Percipients, and my work generally tends to be around helping companies get the most value out of their patent portfolio and to create strategies to do that or to minimize risk. And a lot of it really revolves around how companies make decisions around their portfolio. And so when the USPTO first launched Progress and Potential Report, where they reported out on the number of women inventors, in a best practices group that I co-host, we were talking about how companies could start looking at that data for their own company and to see how they fared compared to what the national average was. And in our zealous naivete, we thought that it would be very easy, that we would be able to get the data quite quickly and we would take a look at it and we would be able to figure out how companies were doing and come up with some best practices and things to do. After a year of companies beating their heads against the wall trying to get the data, we thought, this maybe is going to be a little more difficult than we had anticipated. And we ended up saying, we think we need more companies who want to help create these best practices and things. So that led to the formation of the Diversity Pledge. We initially launched the pledge with 30 companies who were committed to implementing a set of best practices, collecting and sharing data through anonymized data sets, and promoting their practices out into the community. Jeremiah Chan of Meta was one of the leading impetus for us going out to do that. I will say that to get the 30 founding pledgees, we had to talk to 250 companies. And of the 250 companies, most of them were doing some of these things already in their corporations, but they were afraid to go public. And they were afraid to go public because nobody had ever really looked at this before, and everybody knew they were not going to look good. Again, if you've never managed something before and you're going to get a baseline of what you're doing, you don't expect to hit it out of the park. And so it was the transparency that people were afraid of. And so I think one of the things you're going to hear today are the stories from the companies on what they've been doing and the successes and failures that they've had, and how that has affected their internal patent groups, their innovation focus, all of those things. And it's really sort of inspiring. I hope as you go through this that you'll find what they've done to be pretty amazing. But I just want to take just a few more seconds here and level set, because we heard a lot in the last panel about different aspects of how to increase inclusivity. And I want us to understand really, why are we doing this, right? So what was really interesting about being at the patent at USPTO, and I'm actually a member of the Patent Public Advisory Board, PPAC, which is an advisory group to the USPTO, was the PTO has done a really good job in the last 3 years linking invention to increasing the gross national product of the nation, whether it be at the state level or at the national level. So if invention is a driver of GDP, which is jobs and the economy and all of those things, that's why we're really doing this. It actually helps our economy. It creates more jobs. We get more products. Companies make money. This is how we operate at a national level. So this is, while we are here maybe for our own personal passion, it's really to help our nation, right? Increase our economic and technological competitiveness in a very tight race, because we're in an innovation race with other economies, right? And he or she whose economy makes and sells things does generally well. And so we, until I would say maybe the 1970s, were the leader in the innovation space around the world. I don't think we can say that anymore. Other economies are working hard and innovating, and so we need to keep our edge. So just a reminder of why this is important to everyone, in addition to our own personal passion. Frances, I'd like you to take a moment and just introduce yourself briefly.
I'm Frances Winkler. I'm an innovator, and I also manage the IP operations and innovation programs at Pure Storage.
Hi, everyone. Jeremiah Chan. I lead the patent licensing and open source team at Meta Platforms. Also get to be a part of some other great organizations like the Institute for IP and Social Justice, which is represented here today, as well as the Institute for Inclusion in the Legal Profession. But really happy to be here with you.
And Sabra?
Hi, everyone. My name is Sabra Truesdale. I'm one of the patent attorneys at Western Digital, and I also lead She Invents, our female inventor program.
Great. So I want to just turn back to the pledge for just a moment before we dive into the company stories. So the pledge itself says that companies are going to implement best practices and that we're going to collect data annually and find out how they're doing. And so last year was our first year of data collection. And what we found was a few things that you'll see themes in the stories that you're about to hear. The first thing is that language matters, right? What we call these things, how we message it within the companies, does matter. And you've seen some of the panel before us talk a little bit about how the USPTO might be changing some of the language on rejections and how things are messaged inside companies. So that's the first and most important thing. The second thing is that the word inventor is a really loaded word. Like when we think of inventor, people tend to think of Thomas Edison, maybe Tesla, or some of these really big world earth-shattering inventions. Inventors solve problems. And so when you're solving a problem, a lot of people don't think their problem solving rises to the level of invention. So again, we were talking earlier in the previous panel, they self-select out of the inventorship process because they don't think that it's worthy of invention. But again, if you solve a problem, that is something that's notable, and that's really what we're talking about here. The second thing is that in the survey where we asked people if they wanted to provide their women inventor rate and fractional inventor rate numbers to us. Again, the survey's anonymized, so while I know what companies participated, I don't know whose data is whom. What we saw is that there was a 23% increase in women inventor rates from year to year in companies that were implementing programs, which is a huge uptick, right? So when we think about the 13% on national average that we're seeing from the USPTO, you should think that 80% of granted patents go to corporations. So if we want to move that number, we need to get companies individually to work on moving their individual women inventor rate numbers, and that will ultimately move the national average. So I think this is the quickest way that we can get here. The other thing is that when we were speaking with companies, we found that while companies were focused on increasing inventorship with women, all inventorship increased, right? Male inventorship increased. All different demographics increased because when you go out and you educate potential inventors on the inventorship process, you get more submissions, you get more people participating. And so it was nice to see that it wasn't a zero-sum game, which I think is what many people believe falsely, that if you focus on a demographic, others will not happen. It's not true. All demographics increased. And I think now, again, you're going to hear some more, but what the companies are focused on now is looking at uncovering root causes, understanding how you can use data to help visualize what we're seeing around how decisions are being made inside corporations, so that management can make more informed decisions. Again, you saw one of the biggest indicators that women feel is that they're not consistent management practices. And when you can use data to point that out and highlight that, and it becomes very clear, then management will make changes. And so again, I think that's one of the things we're really happy about. So I'm going to first turn it over to Frances to talk a little bit about Pure Storage, and then ask Jeremiah and Sabra to chime in, because not surprisingly, the companies are trying similar things and having different results based on different technology areas and different corporate cultures, et cetera. So I think we'll hear from some of the experts now.
Okay, so last year, we started an Innovator program that included everyone. It was rolled out in our Prague office in November. When we got there, and this is just one example of why I'm so excited about this. We got there in November with 13 invention disclosures from our Prague population. And we had a 5-day kind of a showcase of our program, of the programs to get everybody involved, of the PI2 program, which includes anybody, HR, finance, anyone who has a really good idea, they could submit it through our patent and innovation portal. When we left by the end of that week, we had 32 very good idea submissions. So they were waiting for just permission to innovate. And it was really curious because we ask ourselves often, what are we missing? So we opened that one door, but other doors were not, we set the bar really high. We said, if you have an idea, come and talk to us. What about the people who are innovative and want to be involved? Okay, we got that. That's covered by Pi 2. We found in our, I'm sorry, we found in our survey, well, we found in our survey that people actually don't self-identify as innovators. And that's a gap that we wanted to close. So this year, after our successful pilot of asking everybody with an idea to come and innovate with us, we're going to start another pilot for people to learn how to innovate, no matter what their area of expertise. So that is going to open doors for the people that we reach out to who don't self-identify. And it's going to make our program really accessible to anybody who wants to innovate, because we're focusing, again, not only on certain groups or target groups, we're focusing on everyone. And in the surveys that we have done with Jillian and Colleen, we did focus on those never submitters. And the questions we asked were, do you see yourself as an innovator, the self-identifying portion? And would you like to be involved in innovation? Surprising fact for me was that 60% of the people that didn't see themselves as innovators wanted to be involved. So that was the gap that we were looking for. Whether they considered themselves as innovators or they viewed their roles as not in an innovation center, a traditional innovation center, of those respondents, most were women. Lots of them were new joiners to the company or new pure engineers, or from non-traditional innovation centers such as HR, legal, and finance. We thought that pilot had a lot. We thought the first pilot had a lot to offer. But we wrongly assumed that everyone had an idea that they wanted to contribute, or everyone knew how to contribute their idea. And it's not just showing people how to fill out a disclosure form. It's about actually teaching them creative abilities, those collaboration abilities, things that they can take with them no matter where they go. Some people just don't have that. I think that's a part of our assumption that we are innovative. We are innovators. We think that way. We're curious, but not everybody is. How do you get people focused on that in a space where they're able to innovate for themselves and see themselves as an innovator? So that's one thing we're doing.
Barbara, I know that you guys did a survey as well, and do you want to talk a little bit about your experience with that as well?
Sure. So at Western Digital, we identified who our technical staff was worldwide. And this include everyone from, people actually coding up, our products and creating the devices themselves, but it also included kind of non-traditional technical staff like field application engineers, sales engineers. So we weren't expecting everyone that we surveyed to be an active inventor in our patent program. So I just wanted to say that first. So we sent out the survey to 12,000 employees worldwide that we identified as technical staff. And we got back 3,000 responses, which was great because there was no reward for responding or no punishment for not responding. And so in that survey, we did ask some questions similar to what Francis was talking about, like, do you self-identify as an inventor? And so in that one, we also had asked some demographic questions. It was anonymous, so we did not know the person or their role necessarily within the company unless they provided it. And so for the demographic question, we did ask, which gender do you self-identify with? So we had that data. So when we asked the question, do you self-identify as an inventor? The male respondents were definitely more, like there was a higher percentage who considered themselves to be inventors than the female respondents. And so that was one thing. Another question that we talked about in the survey was if you were, so Francis talked about learning about teaching people about the patent process, and not just, you know, how to fill out the actual form online, but kind of like what is why are you filling out the form? Why are we asking these questions? You know, how can you give better answers so we can better evaluate your invention disclosure? So one of the questions we asked was, if you were unsure whether to submit an invention disclosure, you know, and what would you do? And so, you know, one of, you know, the best answer is talk to someone else, you know, in the company who is more experienced in patents, and, you know, kind of get their ideas on your invention disclosure. But if you were not going to talk to someone else, then what would you do? Would you submit it anyway, or would you not submit it? And the results were striking between the two genders. The male respondents were much more likely to submit their invention disclosure anyway, and the women were much less likely to submit it. And so that's another example of kind of self-censoring and self-selecting out of the process of submitting an invention disclosure. So that's one of the things that we learned in our survey.
Maya, do you want to talk a little bit about your survey?
Yeah, I do. But before I do, I kind of want to back up a little bit and start with a little bit of a story, a personal story, which is I grew up in a small rural town in Illinois, and our family was the only people of color probably within a 50-mile radius. Didn't have a lot of friends, but I have two older brothers, and they were basically my best friends, and we hung out all the time. But I remember we were big time bikers. So every moment we had, we would hop on our bikes and just ride for hours and hours. And we do this every weekend. And I remember every Saturday morning after the school week was over, we'd hop on our bikes early in the morning and we'd take off. And one of the distant memories is always remembering my mom spraying the side of our aluminum siding house in this rural town. And we'd say, "Bye, Mom," and we'd head off. And I thought it was a really normal thing. Fast forward 10 years, now I'm at Berkeley. I'm taking my first Asian American Studies course. And I started asking my parents like about our experience, their experience as immigrants, and then our experience growing up in Illinois. And 10 years later, my mom finally tells me that Saturday mornings she would wash the side of our house because neighbors would throw dog poop as a message to get out of the neighborhood. So I start with that story because that's one of the insidious things about systemic inequality, which is it's really easy to miss it. I mean, it was happening to me and I had no idea. And if you had asked me, I'd say, oh, my childhood was great. And this was happening all the time. And so I start with that story as kind of an entree into our work at Meta, because for most of my career, I've been working with engineers and inventors. I had no clue probably until the Progress and Potential report came out, thanks to the US Patent Office. And it was shocking. And then I said, whoa, what's going on? And by the way, all of my own experiences working with inventors, yeah, it is actually mostly white males who are getting the patent bonuses and the checks from the companies and the accolades on their CVs. And meanwhile, women and people of color as inventors are being left behind. So it really did open the door and open my eyes to just this problem that we were having. Now that takes us to, at Meta, we started working on this problem. And I think part of the challenge here is that for many patent attorneys who have STEM degrees, there is this bias to try to tackle problems and just like go solve them. And for many patent attorneys, we like data, we're technical, but the truth is we have no idea what we're doing when it comes to this issue. And that's part of why I love being at this conference. And I'm so grateful to Margot and Colleen and Jillian and others for putting this together, because we have the convergence of academia and now in-house corporate clients and companies trying to do their thing because we desperately need help. And so one of the things we first did is when we saw the Progress and Potential report, I remember talking to our team about it. We all agreed we're going to do something. So we decided to hold this big female inventor brainstorming session at Meta. We rented a giant conference room, probably bigger than this room, had all sorts of catered food, t-shirts made. It was a big deal. And we had executive sponsorship as well. We promoted it all across the company. And then finally, when the day came, I think we got 5 female inventors who showed up. I mean, people on my team were in tears because they had been working on this event for months. And fortunately, we mustered up our resilience and we huddled together and we said, what are we going to do here? We ended up hiring a design thinking facilitator. We did a full day offsite just to better understand the issue. And by the way, we had this facilitator meet with a number of our inventors across the company. And we just found out that almost all of our assumptions about why women and people of color were not participating in our process were wrong. So that's the first thing I would say to some of you at companies trying to solve this problem. Be aware, be very careful about your assumptions, and really try to learn from the users, which is what design thinking is all about. It's user-centered. I would also say I think about many of the researchers in the room on the first panel and then throughout this room. Even before I met many of them, I still remember seeing different publications that they had shared with the world, and it just spread across our team. We'd say like, oh my God, did you see what Professor Colleen just published? Like, we have to be rethinking how we're working with our inventors. Or Mike Schuster, I was talking to him the other night. Oh my gosh, his paper caused major waves across our team around questioning what we were doing. So a lot of the work that the researchers are doing, they have a special expertise that they bring to bear that's really helpful for us in-house departments trying to figure out how to better engage. Our survey was also a very, very useful tool. I think we ended up getting probably close to 9,000 responses. But again, we were overwhelmed. I mean, we spent hours and hours trying to dissect the results that we got and trying to make heads or tails out of it until we realized we don't know what we're doing again. That led us to ultimately, after talking to people like Colleen and Karen Ulrich Stacy at Diversity Lab and others, we ultimately ended up hiring a behavioral science team from Harvard who ended up coming in and working with our team closely for about a year. And I will tell you, it was pretty painful. I mean, we had a number of sessions. This is after this team came in. They did probably 200 hours of interviews with inventors across the company. They analyzed the heck out of our surveys. And then we ultimately had a number of debrief sessions with my team. It felt like virtually everything we were doing was not inclusive. And I will be very honest with you, many people on my team who pride themselves as being very inclusive and self-aware, they were personally offended that suddenly they were getting feedback from their own client group saying, I don't feel included at all. And so that kind of started this whole process for really auditing all of our programs, changing the language we used. I mean, one quick example I'll give you is I've been using the word patent harvest for my entire career. It turns out we got a lot of feedback from women and inventors of color that they really are turned off by that word. They see a flyer for, come join this patent harvest. And they're like, I'm not harvesting anything. Like, you're not harvesting my ideas. You're not harvesting anything about me. I don't want anything to do with that. So a lot of the language we even used, we had to change. We had to change it throughout our programming, throughout our websites. And in the survey results, one of the things that was really helpful is one of the questions around, do you think you're an inventor? A simple question. We found that women had a far lower yes response rate than their male counterparts. And so one of the things we did is throughout a lot of our advertising, if you will, about our patent programs throughout Meta, a lot of now our landing page, if you go to our Meta landing page, it starts in giant font, you are an inventor. And then it's got a picture of, folks from marginalized communities all represented at a table brainstorming to let people know, like, this is for everyone. We want everyone's ideas. And so it really has, it's hard to even go through the laundry list, but it changed everything for us.
I think that's also one of the things that has really come out from the companies is that how they think about patent prosecution and what it's doing for the firm fundamentally changes. When you realize your job is to ensure the best possible technical futures for the firm, that means you have to go out and get all the good ideas from everywhere that it is, people that you don't normally talk to. They all could have the next best, greatest thing. And so it's really less about sitting in your office and just waiting passively for things to come to you, and more about evangelizing why and how you can invent, how you participate in the process, how we can help you, how you can get people who are solving problems to participate. Sabra, do you want to talk a little bit about some of the work you guys have been doing at Western Digital?
Sure. So as I mentioned in my introduction, I lead She Invents, which is Western Digital's female inventor program. And as Jeremiah mentioned about the Progress and Potential report that the USPTO published several years ago, we read that report too. And I was personally surprised to find out that women were underrepresented relative to their headcount in the inventor community. So, you know, growing up, I majored in computer science. That's my technical background. And I knew that women were underrepresented, you know, during college, looking at my classes. I knew they were underrepresented in the workforce. But I didn't realize that there was a further drop off from the women in the technical workforce to then participating in the patent programs. So it wasn't until I read the Progress and Potential report that I realized that. And so at Western Digital, after we saw that report, we decided to run our numbers. And the numbers were very similar to what was in the Progress and Potential report. So in that report, it's roughly 20% of the technical staff at a company was female, but roughly 10% of the inventing population was female. So there was that drop off that the women were not participating. So at Western Digital, once we realized that that was the case, then we created our female inventor program. And we've been running it now for 4 years. And basically, you know, one of the things we did was the survey that I mentioned. I also did a literature review before the survey. So as Jeremiah mentioned, there are lots of people in academia doing research. There are also lots of companies sharing their stories of what worked and what didn't work. This was back at the beginning, back in around 2020. There was the IPO with their gender diversity toolkit. Now it's just a diversity toolkit. And then there was Santa Clara University School of Law with their best practices. So I did a literature survey first to see what was out there. And then based on that, that's how we drafted our survey. We got our results. That helped us decide some of the root causes that we would try to address. You know, why were the women under participating in our patent process? So we talked about, we discovered that there was, you know, an information gap. And so that's what Suzanne was mentioning, like, it's our goal to teach all technical staff at our company how to participate in our patent process. First of all, we have a patent process. Second of all, how do you participate in it? How do you participate in it well so that your idea is more likely to get approved as a patent application or a trade secret? So those are some of the things we've been trying to help with She Invents. So I've created educational materials. And the impetus for creating the materials was to help our female technical staff, but the materials are available to everyone and they're helpful for all junior inventors. You know, like I wrote a document. Okay, you have an idea. What do you do next? You know, it's about developing your idea and talking to your coworkers, making it better before you submit it as invention disclosure. And then I created a video which walks you through the invention disclosure form and why are we asking these questions? How can you better answer these questions so we can better evaluate your idea and your invention disclosure? So, and in addition to that, we've also, I've been tracking all of Western Digital's patents that list female inventors. We have a running list on our internal website. We created an internal website on our intranet for the She Invents program. It has these educational materials. It has the list of patents. It has a list of articles about our female technical staff. And then finally, we have mentoring programs. It started off in Israel at the very successful mentoring program where we pair junior inventors who are female with experienced inventors who can be male or female. And they work together to help the junior inventors draft invention disclosures and submit them. And then that has now blossomed into a mentoring program in India, which is very successful. It's in its third phase, its third round of pairing mentors and mentees. And that one is so successful that women who have participated as junior inventors, as mentees in earlier rounds of the program are now mentors in later rounds of the program. And it has really, you know, kind of catalyzed the female technical staff in India and made them very excited about participating in our patent program and more engaged at work, which is really nice.
Great, thank you. Frances, do you want to talk a little bit about your hackathon?
So we recently had a hackathon that was focused on AI because it's the next big thing, or has been the next big thing. And we never participated in or were involved in, as the patent department, hackathons. We were never involved in that portion of innovation for some reason. So I said the winners will be submitting their ideas through our IDF portal just to get them involved and get them engaged in the patenting system. They're doing the hackathon as part of the creative process that engineers usually go through, or actually it was open to everybody. So finance was even involved in this hackathon. There were teams from all over the company, and it was really interesting because most of them weren't aware of the patenting program and weren't aware that we gave incentives for disclosures. And so to get them familiar with that, we just put it out there and said, hackathon winners, hackathon participants can come, and if you submit through the portal, you will be an innovator and go through the process. We'll put your idea through the process. So they got an experience just by being involved in a hackathon that we were never included in, just building the community of innovators for ourselves.
Find that it got people to recognize that they're innovators, that they weren't thinking that way before?
I think so. A lot of them had not been involved with us. They were on a never submitter list, and they were counted as actually engaging with us in the survey because of the hackathon. The connection was just missed for us. Hackathons don't have to do with innovate. Well, no, they are innovation, right? So why aren't they being submitted to the patent innovation portal? And we're doing that with the next one. Finance is actually having a month-long hackathon because they're busy as finance. But they're having a month-long hackathon to be creative in their, to use creative AI in their business and how they're, changing and innovating in that area. Why aren't we capturing these things? We never did before, but we're doing it now. And that's what the real essence of our program.
So Jeremiah, if you take a look back at your journey at Meta, what are some things that you would share with people, some takeaways to be helpful? Because frankly, I think you're one of the few companies that brought in a behavioral scientist and have done it there's more bootstrapping going on. And so what could you share out of that for the people who won't have that luxury?
Absolutely. I'd start by saying a comment you started with, Suzanne, about, for a lot of companies I talk to, they will say, well, we don't have your resources or budget. It's fair. I'm guessing Sabra might be sick of me at this point because I've directed so many people to her to show them that you don't need a giant budget or a big staff. I mean, just constantly inspired by the work that a number of companies have done, including Sabra, basically single-handedly. So that's the first thing I would say, which is you can start with basically anything. There are a number of learnings that we've done. One story does kind of jump out at me, which is I mentioned before that our team took it pretty hard on the chin when they got the feedback that we basically didn't know how to be inclusive. And not surprising given that it's been a very inequitable system for a long time. And so why would we know any better? There was one attorney who took it especially hard, but it's interesting to see his own journey. And with his permission, I can share his name, Kevin Ahlstrom, because he's actually published about some of the journey as well. But thinking about his starting point and how he had been doing brainstorm sessions, for instance, for years. And then after getting the feedback, starting to work with a number of our outside counsel. And this is the other thing I would say, just looking across this room, we have a number of our trusted outside counsel who are here. For many companies, I know they don't prosecute in-house. And so we're partnering really closely with a number of law firms out there. And one challenge that I see with many companies is they might be working on inclusive innovation initiatives within their in-house departments, but they're not really partnering closely with their outside counsel. So you have kind of a disconnect, even though your outside counsel is extremely involved in working with your inventors. So we tend to partner really closely. Kevin did with one of our particular outside counsel, and they started testing out different approaches for brainstorming. This is just the process of gathering invention ideas. One of the approaches they ultimately settled on is a pretty well-established approach called the 635 brainwriting method that the TLDR is, it's just a much more collaborative way of innovating together. It's a much more team-oriented approach. And one of the ideas about it is rather than going to a big room of inventors and saying, what are you all working on? And the loudest voice in the room just monopolizes the whole time. And I've been in that situation many, many times. They actually go through a system of people come up with ideas around a particular technical problem that they're trying to solve. But then after 5 minutes, they pass their idea to the next person who then is actually asked to improve upon the idea. So it's extremely collaborative, and tracking the results over now, I think a year, they have found a massive increase in participation and idea submissions from our female inventors. So that's worked really well. And I think, again, it just goes to questioning the assumptions of many patent attorneys out there who I know are like, our process is inclusive. We don't exclude anyone. But the fact that you don't exclude people explicitly doesn't mean that your process is inclusive, right? And we know from the data now that it's not, right? People are being left behind. Your system of doing things isn't working for everyone.
Yeah, and I think that, as we go out and we talk with companies, many of them assume because they have good training programs, they don't have an issue. But when you look at the data and you look at their women inventor rate and you look at the amount of women in their technical fields, they have an issue. I mean, honestly, there's nobody that's killing it right now. So it's interesting. Again, when you start with a new area, you have to get a baseline and then figure out how you want to improve. Sabra, I'm going to come to you last because I also want you to talk a little bit about working with outside counsel and in particular about attribution.
Sure. So as Jeremiah mentioned, we're one of the companies that don't do any preparation and prosecution in-house. We do farm that out to all of our outside counsel. So one thing that we're doing, so everything we've been talking about so far has been talking about inclusion for the technical staff themselves in participating in the patent process. But kind of another side to the same coin is the inclusion and diversification of the patent staff who are working on, to support these inventors. So, if you're an inventor or an innovator and you have your idea and you're seeking help from a patent attorney, it can help if the patent attorney has something in common with you. Maybe they're the same gender or the same ethnic background, and so in the old days when maybe it's still true that I think most of the patent attorneys, the registered patent attorneys in the United States are white males. But now at least there are more females participating and more non-white people participating as registered patent attorneys and agents. So it does help when you have a more diverse patent bar. It does help the inventors who are diverse better participate in the patent program. And so one of the things that we did at Western Digital is we said, well, we want to also help the diversity and inclusion of the patent staff. So we changed, so first of all, we learned about this issue from Professor Jordana Goodman, and she's going to be speaking later today at this conference about another one of her articles. This particular article was from a few years ago called Ms. Attribution, and it had to do with the practice of some US law firms of having the partner, like regardless of who wrote an application or who wrote an office action response, even if that person had a reg number at the PTO, the partner would still put their name on it. And the registered attorney or agent would not have their name listed anywhere. And so when I was at an outside law firm, before I came to Western Digital, I was allowed to sign my own applications and office action responses once I had a registration number. That's just what we did. But some patent law firms don't do that. For various reasons that are talked about in the Ms. Attribution article, these law firms chose to not have the registered patent practitioner have their name on it and instead only have the partner's name. So it turns out that they're kind of like ghostwriting. There's these outside counsel, junior patent attorneys and agents, they have numbers, but their name is not in the PTO record anywhere. And so it creates kind of the snowball effect because they don't have any proof that they did this work. They're not listed in the PTO record anymore. And it's always just the partner's name listed over and over. And the partners traditionally are less diverse, right, than the junior people. And so it just became more of a snowball effect in terms of like, you know, if people look through the prosecution record of a case, they're only going to see the partners' names who are not diverse. They're not going to see the junior patent practitioner's name. So what we did at Western Digital is based on the learnings in Jordana's article, we changed our outside counsel guidelines, and they had never said anything, you know, about who signs an office action response or who signs an application. We told our outside counsel from now on, and we made this change about 6 months ago, whoever spent the most time drafting the application or drafting the office action response must have their name on that document, as long as they have a reg number, when it's filed at the PTO. Now, if the firm wants to include additional people, like the partner, if there's space for additional signers, that's fine. But you need to include the person who billed the most time and who worked the most on it, and that's going to be the junior people. So we made that change, and it was inspired by a particular situation with one of our outside counsel, where I kept getting, you know, draft office action responses from a female associate, and she clearly had been the one to write it, but her name wasn't on it. And so that was my inspiration for making this change. And so I did publish about it on LinkedIn, but now we're trying to spread the word even more through this conference. And also Western Digital is planning to join ADAPT. And so our outside counsel guidelines regarding patent practitioner attribution will eventually be available on the ADAPT website as one of the initiatives that you can take on at your company for your outside counsel guidelines.
So I think we're coming to an end here. But I want to say thank you to the panelists for sharing their stories. And for those of you in the room, please feel free at the break or at lunch to come and talk with them for more information. They're doing great work, and you know, we're having success. So kudos to all their hard work. Thank you.
Thank you so much. That was terrific. And I do want to put a plug in for ADAPT. And Michael Vins, I hope we'll talk a little bit about the program later as well. But for sure, in terms of actually trying to find practices, find other people who are working on and have pioneered and piloted different practices, that's definitely a resource that's available to you, as well as the PTO resource that was talked about earlier. So I think we're going to be shifting now to our keynote speaker. Is Petra keyed up? We are really thrilled to have Petra Moser, who is a real pioneer in research, talk about her work. Let's see if we can ensure that she's in the Zoom. And I also want to give a shout out to Jordy Goodman, who will be talking about her other research later. But this paper, which she presented at the Diversity Pilots Conference 2 years ago, I think the kind of culmination of just getting her work elevated and then companies saying, wow, that is really a great insight, we can do something about it, is exactly the type of collaboration that we hope to support here at the Diversity Pilots Conference. And so we're excited to see also how that proves out over time in terms of diversifying who is getting credit, and hopefully this practice will be something that spreads. So a lot of kudos to Sabra Ann as well as to Jordy. And it looks like Petra is here. So
yeah,
terrific.
But I can't share my screen. Somebody has disabled screen sharing, so I can't actually.
Oh, good. Yes. She'll be presenting her new paper, Ms. Allocation of Talent. And she's really going to take a very holistic look at this question of the innovator gender gap and what we can do to, you know, shift talent, to shift the allocation of talent, how much that can close this gap. She is a professor of economics at the NYU Stern School of Business, and she's done just groundbreaking research in a lot of areas. But what's really unique about her is that she combines empirical microeconomics and economic history to look at questions of what determines who is participating in creativity and innovation. And she not only focuses on patent, but also copyright laws and looking at how they affect science, technology, and the arts. She's done some really interesting research, especially on the impact of immigration to the United States and the biological basis for entrepreneurship. So I'm going to turn it over to Professor Moser to give her presentation.
Thank you very much. So I think I have 30 minutes, right? or I should just end at 11:55. Is that correct?
Yes, you have until 11:55. If you want to take some questions
perfect.
as part of that, then that's fine. Yeah.
All right, I will. Okay, thank you so much. Thanks for having me. It's a real honor to speak at this conference. I will talk today about scientists. I think in line with the topic of this conference, with the focus of this conference, we will talk about misallocations as a result of biases. And this is joint work with Moritz Lubczyk, who is now a postdoc at the Rockwell Foundation Berlin. So why do we want to look at women in science is because women continue to be severely underrepresented in innovation and in STEM. That is, even though since the 1960s, there have been enormous advances in representation, and these advances have, if you do growth composition exercises, they can explain up to 40% of productivity growth. So just as talented women and Black men have entered high-skilled professions, US productivity has grown. Despite these increases, however, women continue to be severely underrepresented in STEM, and particularly among inventors. And so this is data from Bell et al. In 2019, where they look at the share of women inventors among different birth cohorts. And so what you see is that at current rates of conversions, it will take 118 years to close the innovation gender gap. So what we do is we look back in time and see how the same gap actually looked 100 years earlier. We want to try to use this data to examine how different types of how shifting women into STEM, whether shifting women into STEM could close this gap. And what we use is a source of data that I've been now digitizing, collecting and digitizing since 2015, and it's called the American Man of Science. It's a biographical dictionary that was first collected by the first professor of psychology in the United States, James McKean Cattell. Despite its name, it includes both male and female scientists. So now, with any type of historical data, you always want to ask, like, how do people get into this data set? The way people get into this data set is by being a member of any type of scientific organization, or by being listed at a university catalog, or by contributing to a scientific journal. So this is really a very, very comprehensive data set on American scientists. I'm going to just walk you through a sample entry to tell you what's in the data and how we're going to use it. So we'll have the full name of each scientist, and we'll use that name to assign gender based on Social Security Administration records of male and female names. And then we'll match that with publications and with patents. We'll have the birthplace and the date for each scientist. And what that allows us, it allows us to look at the series that I just showed you a little earlier. And specifically, we'll now look, using our data, we're looking at the same things that people look at with contemporary data, with historical data, starting for people who were born in 1920. And I think what's really striking here is that this trend that we see today that has these really low rates of convergence actually already existed in the 1920s. So you look, this is pretty much just a straight line going from our data to this contemporary data. If you look a little bit more closely at what these scientists did, one thing that we notice right away is that just 3% of scientists in the physical sciences are women. That is compared with 9% of scientists in the social sciences and 8% in the biological sciences. So the first thing we see here is that women are really underrepresented in the physical sciences. Now we're going to look at whether shifting women into the physical sciences could actually encourage a greater participation in innovation. So how do we do this? So first, we measure the year in which each scientist enters science. And then we'll also collect data on the discipline and the research topics. So Colleen has very nicely introduced me and said that I'm an economic historian. One thing that I didn't think I was, or one thing that I didn't anticipate I would do as much of as I am doing right now is text analysis. So what we're doing here, we're using the text that describes the research of each scientist to assign them to fields. And specifically, we use k-means, which is like the simplest text analysis you can do. So we basically just use the text that describes this research of each scientist, and the algorithm converts each entry into an entry of a giant matrix where each scientist is a row and words are columns. And if a word occurs in the specific text that describes the scientist's research, it's a 1, otherwise it's a 0. Then the algorithm downweights like really frequent words like research, upweights really infrequent words, and then kind of does an OLS to just assign each scientist to the cluster to the field in which they're that's most closely related to their research. So why do we do this? Well, actually what this allows us to do, it allows us to identify overlap between research that we wouldn't find by just trusting what scientists say they study. For example, let's look at these two guys. So this guy says he's an engineer, and this other person says he's in physics. But when you look at the text that describes their research, what you actually realize is both of them work on landing gear for aircraft. The k-means algorithm recognizes that. And so we use the k-means algorithm to assign everybody to fields. Then the next thing that we do, we will use an exogenous shock. We will need an exogenous shock to move women into science. And what we do here is we use World War II. World War II drew many, many men into science. And we want to know exactly how many and how many per field. And what we do here, this matching is from a different paper with an undergraduate student, where we look at PTSD and scientists. But what we do is we're matching every scientist with 8 million enlistment records in the archives, in the National Archives. So I'm gonna not go through all of that, but you can imagine that that's super computationally demanding. So we have 80,000 scientists that we need to match with 8.4 million unique names in the enlistment records. That is about 500 billion potential matches. So all of this graph here is just the different methods that we all use to narrow down the potential matches and then find the best match and do that quickly enough so it's actually is done in our lifetime. And so now we can match every scientist with the enlistment record. So now we know how many scientists are enlisted in the war, in World War II. So then what we see is that I think, is really striking graph. The gray line is the enlistment of male scientists. And then I think what's really striking is that this is female entry is the black line, and women enter as men leave. So as more men go into the army rather than to science, women are drawn in. So women are now drawn into science, and we can use that as an exogenous source of variation to get a causal estimate of moving women into science, and specifically moving women into STEM. So, but before we do this all, we want to just run our basic OLS that will allow us to look at different forces that we can imagine. So there are many different reasons why women may not patent. And I'm going to just go through them and see how much they matter in our data. The first one is that women might be less productive. So they have maybe fewer publications for a number of reasons. they could also more likely to abandon patent applications, or they could be less likely to get credit. So for instance, one story that I ran into in the course of this research is that Albert Einstein had worked on some patents with his first wife, but the wife never made it onto the patent application. So something like that could happen as well. Women could be more likely to choose academia and then they publish rather than patent. Or, and I've worked on this in a different setting, they could get married and become mothers. And when you have a mother, you have less time, so you may patent less. You may have a negative productivity shock. Or, and this is what we'll focus here, is that they work in fields in which male scientists patent less. So what we're going to focus on is that women might, or what we actually see is that women become psychologists, the talented women become psychologists, while talented men become engineers. And so now we're just going to throw this all into an OLS specification where we're trying to explain the probability that a scientist becomes an inventor. And we will use this indicator for female as an explanatory variable. And then we'll throw in a bunch of controls and we essentially see whether we can kill this coefficient, whether we can explain the low share of female inventors with some explanatory variables. So the first thing you see is that just without controls, female scientists are 19.4 percentage point less likely to patent. Now, both female and male scientists are more likely to patent if they publish more. So this is the productivity channel. But when we control for the productivity channel, the coefficient is still there. So that does not explain much of the variation. It doesn't explain much of why women don't patent. Now we're going to look at the next one. So it could be that female scientists are less likely to have a PhD. In fact, actually, women are more likely to have a PhD. And partly that could be a sign of discrimination. So they actually feel like they have to get a PhD. But male, but not female PhD scientists are more likely to patent. That explains a little bit more of the variation. But still, there's a lot of the coefficient left. So even controlling for PhDs, female scientists are 16.6 percentage point less likely to patent. Then the other channel is that, well, maybe women go into academia rather than industry. And we find that both men and women are more likely to patent when they are in industry. But even when we control for that, female scientists are significantly less likely to patent. The last one is marriage. So actually one result that I think is kind of striking when you see it for the first time is that women become less productive when they have children, but men actually become more productive. But even when we throw that in, that kind of doesn't explain why women don't patent. Now, we'll look at this last factor, which is like, are women more likely to go into fields like psychology where they don't get to patent? And so we see this here, like both men and women are more likely to patent when they go to STEM. And when we throw that in, then actually that coefficient gets reduced dramatically. So what we see in the simple OLS regression is that controlling for doing research in STEM, female scientists are just 4.3 percentage point less likely to patent. So it's actually whether women make it or don't make it into STEM explains most of this lack of women, of this low probability of women becoming inventors. And I can show you this in a graph. Graphs are always better than figures, than tables. So these are all the other factors. And this is whether you are actually in the physical or the biological or the social sciences. So now let's try to get some causal estimates. And so the way we get the causal estimates, as I already explained, we will use the variation in exposure to enlistment as a force that shifts women into STEM. Here, I'm going to show you this enlistment data in another way. So where we have the year in which men and women enter science, so which we get from this Man of Science data. And so what you see here is that after the draft, the World War II draft had started, many fewer men enter science. And what's really striking here is that women enter science as men don't enter. So, and that's going to be our shock. Now, I'll show this to you at the field level. Most of our analysis is going to be at the level of the research fields for today. And what we see is that fields in which more men enlisted have more women entering. So women enter fields in which more men leave for the war. And so that's what we'll use to move women into STEM. That's our exogenous shock. Just another way of showing you that variation. In the median field, 20% of draft-eligible male scientists enlisted. And now looking at this variation over time, this is the black line is fields with above median share of enlistments. The interrupted line is below median enlistment, but you see they look very similar before. But after 1939, after the beginning of the war, more women enter fields with high shares of enlisted men. You do this as an event study. You see there's no real difference in these fields before the war, but after the war, more women enlist. So when we put this again in a regression, what we see is that a 10% increase in enlistment leads to a 42% increase in the share of female entry. So it's really powerful that there's this big change in female entry in fields in which more men enlist. So now we're actually going to look at inventors, because what we're really interested in, what we started out is like, does shifting women into STEM, does that increase the share of inventors? So we use this variation created as a result of the war, this variation in enlistment, and we compare the number of female inventors in fields with high and low share of male enlistment. Again, before the war, they look very, very similar. And after the war, there's many more female inventors in fields in which more men enlist. So this kind of graph would basically, I'll do a bunch of more analysis right now, but it already tells you kind of everything you need to know about the analysis. Is there's a huge shift a huge increase in the number of female inventors in fields in which more men were drawn into the war. So now that's the IV. So the IV is going to compare fields with high and low levels of exposure. And I'll skip this. So what do you have to believe for this analysis to be true? This actually is a little bit like, well, I just tell you. So for this analysis that I'm about to show you is going to estimate the causal effect of moving women into STEM on patenting. And the only thing you have to believe, or the thing that you have to believe for this to actually show us a causal effect, is that conditional on the trends in female entry at the field level before the war, an increase in the share of enlisted men in a specific field only affects the number of inventors in that field by increasing the number of women entering that field. So that's the only thing you have to believe for this to estimate a causal effect. And actually, we can't really test this, but we can kind of see whether it's violated in some way. And so one thing we can show is that there's no correlation between enlistment and openness to female entry before World War II. So it looks like a pretty good assumption. And if under that assumption is true, then what this regression now tells us is that moving 5 additional women into the physical sciences increases the number of female inventors by 1. So for every 5 women you move into STEM, 1 of them is going to be an inventor. So now we're going to use this to think about what would happen when we move women into STEM. But first I want to kind of tell you like, okay, I'm a historian, so I'm kind of asking you to think about war. And so one thing we want to see, one thing we want to be very careful with is like who actually entered during the war. So we want to be sensitive to the historical realities. And so who entered during the war? And these women who entered during the war, they were a little different from other women who entered before or after the war. They were more likely to be younger, below 20, or older. So 28 to 40 years. So I think the way we interpret this is that women with young children did not enter the war effort. It was either those who were not yet married or those who were married, but already the kids were old enough so that they could actually so that they could go and work. And a lot of so if you want to think about the quintessential woman who entered science during the war, would be somebody either who would like dropped out of the labor force to raise children, or it could be somebody who actually was a teacher and say a math teacher, and then kind of started working either in science. So got pulled out of high school teaching or other teaching kids to being a scientist. So now let me show you what that gives us. So we're going back to this original analysis. So when we actually look back at this graph, we look back at, this is the data today, this is the historical data. Now we're going to use these estimates to see how things would change if we could move more women into STEM. So suppose women participate in STEM at the same rate as men. So if we could get women to participate in STEM at the same rate as men, and if when a woman enters a field, they pattern at a rate that is implied by our instrumental variable regressions, by this estimate that I showed you earlier, then we can use this now to predict what would happen if women entered STEM at the same rate as men. So that's the IV estimates. The IV estimates tell us the slope for the data that we have for women born until 1930. And we're now going to extrapolate that to get an idea of how things would change if we could move women into STEM. And so the time to parity would be reduced dramatically. Our estimates imply that if we could move these women into STEM, we'd reach gender parity in 47 years rather than 118. And since I only have 4 more minutes, I think I'll stop here. Any questions? Or I can keep going. I don't hear anything from your side. Still don't hear anything? Let me see. I'm gonna stop sharing my screen and figure out what's going on.
And then last but not least, Derek Rowe from Wilson Sonsini. And each of them are going to talk about a particular initiative at their law firm. And one of the great things you're going to see at the end, we even arrange the seating in a particular way because the different projects that the different initiatives that their firms are doing, it actually fits together as if they sat down and mapped this out decades ago in terms of the ideation technology transfer pipeline. And, for those of us who do IP, nerds, we say, oh, technology transfer. All it means is getting the results of the ideas into actual products and services and then getting it out into society. And so you'll see that they represent a complete ideation technology transfer pipeline, getting people into the innovation pipeline at the very beginning, providing them with the right type of assistance such that they continue to move through it effectively, and then ultimately getting the results of that intellectual property achievement into the hands of society and assisting innovators at that part of the journey as well. So with that, I'm going to turn it over to Tony to talk about the initiative at your law firm.
Thanks, Latif. As Latif mentioned, my name's Tony Josephson, practitioner at SLW. And I've been practicing since the last century too. And prior to that, I was an engineer at NASA. I was involved with deep space probes and satellites. And trust me, that'll have relevance in a few minutes. I'm not doing that, not saying that to be self-indulgent. So what is SLW doing? We're involved with the SLW Academy. And how do we get involved in that? Well, leadership at SLW for a long time was trying to figure out a way, DEI initiatives, how can we expand that? And then George Floyd happened, and the George Floyd incident, rather. And our firm is headquartered at Minneapolis. I mean, some people call it the mothership. It's a block from the Hennepin County Courthouse where the trials took place for those that were involved with it. So we had a front seat. I mean, everything was boarded up. I mean, we were right there. And it kind of really just lit the fire. And the firm was like, the leadership was like, well, we have this expertise in the IP world. So how can we use that to further advance DEI initiatives? And that was really the genesis for SLW Academy. So what is the SLW Academy? And it's, so far this morning, we've had people talk about, trying to get inventors to submit more disclosures and see their applications through to patenting. So it's more on, for lack of better words, the back end of the process. We're more on the front end of the process. And what I mean is trying to get more people into the patenting profession, or at least consider it. So what exactly is it? It's trifurcated into three different segments, three different portions. We have a high school portion, a college portion, and a law school portion. So what's the high school portion? It really discusses IP at a very high level. Just what the definition of IP is, property of the mind, the different types of IP, patent, trademarks, copyrights, trade secrets, just to expose the users of the program to the different types of IP. College portion, what exactly is that? It dives a little bit deeper into IP. Taking patents as an example, it discusses what the requirements are for patents, as we all know, ineligibility, novelty, non-obviousness. And it also talks about what happens at the patent office when you initially file a patent application and the interactions between the practitioners and the examiners during the whole patenting process. And one thing about this, and I think it's somewhat pertinent to what we've heard so far today, and I didn't realize this at the time we were putting this, the SLW Academy together, but it's almost like there's certain things that we talk about at the college level that can be pertinent to engineers and scientists. Maybe they just may realize that, yeah, it's patent stuff, not really for me. But one of the things we talk about is, the duty of disclosure. And we talk about certain aspects of patenting like public disclosure. And, everyone here knows what that means. and what the ramifications are. And we also talk about disclosure meetings, like what to expect, what happens, who attends, what you should bring. And then at the law school level, we dive a little deeper. We talk about the statutory requirements for getting, for example, for a patent, the always fun 101, the standards of burden for the patent office, how you can counter the rejections. Same thing with other aspects like novelty and obviousness. And we delve into the same things with trademarks and copyrights. So that's grand, that we have this SLW Academy, but, how does that really expand DEI initiative? I mean, I'm not gonna lie, when we're going through this, I was kind of thinking about that, but then I realized this is definitely something I could have used, last century. And what I mean is, as I mentioned, I was an engineer at NASA, and I got my engineering degree because I didn't know what I wanted to do. I figured I'd get an engineering degree because I can pay rent. So I started at NASA and I realized I want to be a lousy engineer. I really need to do something different here. I mean, things will start falling out of the sky and I just can't do that if I'm an engineer there. And, this is before, Al Gore invented the internet. So there really wasn't any way for me to find out what someone with an engineering background could do. And it really spoke to me because my parents are first generation immigrants. So my entire family are first generation immigrants. And, they had a lot of them had jobs that first generation immigrants can have. And, feel free to read into that whatever you'd like. I mean, we didn't have any engineers, we didn't have any lawyers, and we certainly didn't have any patent lawyers. So, you know, what was someone like me or someone similar situated to me supposed to do? And I got lucky. I had a professor in college. He said, "Oh, my son is a patent lawyer. You should think about that." I mean, that was just pure dumb luck. I mean, but for him, I don't know what I would be doing. Certainly not an engineer. And that's really where SL Academy comes in. I mean, it's free. Anyone can log on to it. Anyone can use it. And, let's be honest here, at least 90% of the people out there have a phone with internet capability. I mean, I envy those who don't. And, everyone has it. So, if you're an engineer or a scientist and, you're like me, you're like, this really isn't going to work out for me. You can do a Google or Bing search or whatever search engine you like, and eventually you'll be led to SLW Academy. And I feel like from a DEI, initiative expansion perspective, that's the real advantage with SLW Academy. Thanks.
So, got it to work. So here we see at the beginning of the pipeline. I mean, some people who are outside of the pipeline altogether, either not even thinking about STEM, certainly some people who are in STEM, but not thinking about patent law, not thinking about intellectual property law. And so that initiative is getting people who would otherwise be outside of the pipeline into it, right? But then we all know once you get into it, it's like, okay, I know where the water is. I'm kind of swimming, but I want to do more than just float. And then I think that that's where the Finnegan Initiative comes in.
It is. Thanks, Latif. Mine is working, I think. Yes? Okay. It was fun for me to hear Tony talk about how he landed in IP because I actually have a very similar background where I did not know patent law was a thing, and I was fortunate enough to be seated in the right auditorium where a patent attorney was talking about how if you think you're going to be a terrible engineer and things will fall out of the sky if you're designing them, which would have also been me, this could be something else. So I'm going to talk a little bit. My name is Kara, by the way. I'm with Finnegan. I lead our women's group and I lead our LGBT affinity group. So I'm going to talk about two different programs that Finnegan has that really do parlay nicely off of Tony's program. Our first one is called the IP University. So not with high school students, but this is a program, free, virtual, online for folks in undergraduate and graduate programs, in STEM programs that maybe are starting to think STEM is great, but I might want to do something slightly different. What other options are there out there? And so this is really a nuts and bolts academy. Not to steal your word, ours is a university, but it is, I think, quite similar, aimed towards building up future practitioners, whether that be innovators, whether it be patent agents, giving people an understanding of intellectual property and of the patent system. So what we do is a nuts and bolts overview of the US system, and this includes the basics of drafting patent applications, for example, the process for prosecuting those patent applications before the Patent and Trademark Office. And there are some opportunities as well where we do tours of the USPTO for folks that are in DC and want to kind of see how these work. We do get some examiners involved along the way as well. So it's supposed to be kind of an entry level, free to sign up, wholly virtual. You're thinking about going into this field. Maybe law school is for you, maybe it's not, but you're looking for something different. Let's say you've completed that program, you loved it, and you're thinking about taking it to the next step and going to law school. So Finnegan offers what we call the IP Summit. And this one truly is a diversity initiative. While the IP University, we do target specific universities and highlight this for folks who might not otherwise be exposed to the legal profession. The IP Summit really is the next step in the process, and we target specifically African American and Black law students. So these are people who are already in law school, perhaps have completed our IP university and took the next step to go to law school. And this one is much more immersive. So we actually bring all of the law students to Washington, D.C. to the extent they're not already there. We get a huge turnout from Howard, by the way, for this. So thank you for supporting us. For a multi-day conference, and we bring in-house counsel, practitioners from Finnegan, folks from the PTO. We have PTAB judges who participate. We have examiners who participate. There's some folks from the TTAB that also participate in the program. The idea is really to foster that curiosity and get people aware of, look, these are the different pipelines. Now that you're in law school, now that you're interested in the IP profession, here are the stories and the backgrounds of people that look like you, that have similar tracks that you have, and building that out to make sure that it's not just educational. There's certainly a huge educational aspect to this, but also networking, social interaction, and making sure people understand that they have a support network behind them to take the next steps. It's also a great recruiting tool, I will say, from the law firm perspective. Both of these are fantastic. We hire many people out of the IP University to become student associates, where the firm actually pays for them to take the next step into law school. And then the IP Summit, of course, is fantastic for those people looking for a summer associateship position, looking to step into either private practice or to connect with people on the in-house side that they meet through the program to pursue different careers and really to get a view of what's right for me. In-house, law firm life, government perhaps with the PTO, and just to give kind of a holistic perspective and really to build a support network for people that are looking into going into this profession and hopefully looking to stay in this profession long term.
Well, two things that occur to me. The first is that, we think about how these initiatives can benefit society in some obvious ways. From what you two just said, here's a way I hadn't thought about. I mean, these programs save lives because both of you would have had things dropping out of the sky. So this is very helpful to know. We've seen now, right, that what have these two initiatives done? They have taken people, you put them two together, you take people who otherwise would not have ended up being patent attorneys, not have ended up being IP attorneys, and look at this. 25 years ago, it was said, this is not a law firm problem, and now it is two law firms going out there as IP evangelists, right? Johnny Appleseeds going across the country and planting these seeds, and then people are actually becoming IP practitioners. And then we get to the final stage of it, and let me hand it over to you, Derek.
Thank you. Thank you for having me as well. So I am Derek Rowe. I'll just go over my background. So undergrad chemistry, and the reason I'm going over this is because you'll see where things go as far as where we focus. But I have an undergrad in chemistry, a book of pharmacology, physiology, master's, and neuroscience PhD. As far as becoming a patent attorney, that was not necessarily the plan, but for making certain decisions, that's where it ended up. I'm a partner at Wilson Sonsini in the DC office. Closer? Okay. Thank you. And so our focus mainly is on startup companies. And that is from, an individual starting the company all the way through product launch, IPOs, getting bought by a larger company. Specifically with regard to the life sciences, you can see my background kind of focuses on that. With regard to the different initiatives that we have, because we typically interact with, of course, lawyers, VCs that invest in those startup companies, and of course the founders, I'll put basically our programs into those different buckets. With regard to students, we do sponsor foundations where we go in and help with resume drafting, also applications, so on and so forth, to get them through the pipeline. We do also pair them with mentors, basically to inform them about IP law, of course. But we have other programs as well where if you're a corporate lawyer, you'll go into that bucket as well, where you get paired with a mentor in that regard. We also support other programs where myself and others like me sit on panels where we talk about, okay, how do we get where we are currently? Right? Because my story is different from yours, but you may be able to find some parts of it that aligns, and we may have a conversation afterwards with regard to how you navigate certain things. So helping to give that perspective and that you can make it through the path if that's the path that you want to go on. Of course, there's different paths to go on. And we also have 1L diversity program as well, focused on underrepresented minorities and women. And so we bring those students in, typically law school students, bring them in and again, partner them with individual to say, okay, this is what big law is about, right? To give them a view of that. I was the first in my family to enter into the legal sphere and also big law, and so I didn't know what I was getting into. So, looking from my experience, that's an incredible program where it says, "Hey, this is what this is like," and some choose to go that direction, others choose not to, but it's just to educate about what that's like. But when we move over to the VC side, we also have a next gen VC podcast that Wilson puts on. And generally speaking, it's about finding the next generation of VCs that are coming through that will invest in different companies and providing a platform for them to talk about themselves, but also what they're focused on. And within that, there's definitely a series where it's focused on diverse VC individuals to say, what is your story? What are you focused on? Here's the Wilson platform to reach out to others. In that space as well, we do sponsor and we do sit on panels or boards of different initiatives, Women VC, for example, or Women of Color Venture, those kind of entities. We sit on those and we help kind of provide education with regard to what's going in the life sciences space. Because from my understanding, VCs don't necessarily have a course or some kind of school that they go to, right? You decide to be a VC and you kind of go that path. So we try to help them in that regard. On the side of the founders, what we do is that we sponsor different incubators. And within these incubators, you have different pitch competitions. And specifically with regard to focus on underrepresented minorities and women founders, where we go in and we mentor, we help them with their pitch decks, we help them basically understand what this process is going to be like. And again, in the life sciences, it's a pretty long path of many different minefields. And so try to give them the outlook as far as how to navigate those different things. And of course, at the very end, there's a pitch competition. There's a winner who gets certain sums of funds, but also for these incubators, they have a 1-year lab space placement in these incubators. So it's a massive benefit with regard to resources financially, and also the fact that you have certain tools that you could use and network within some of these established incubators as well. So those are some of the programs that I personally am involved with, but Wilson, is involved in a lot of others as well, and there's always room to do more. So if you have ideas of different initiatives, definitely reach out and see if we could partner.
So great. So we intentionally talked about each of the panelists having just a certain amount of time, because we wanted to leave time for people in the audience to ask questions about these initiatives, either to get details or further ideas as to how individuals in the audience could replicate these initiatives as well. So if folks have questions, all you have to do is just stand up. You may have to yell, or I'll put a microphone down your path. And just while you're getting ready and trying to get ready to decide what question you want to ask, we decided that, okay, in case people are shy, we had a couple of backup questions, but we only have 3, so we're counting on you. Okay, all right. So start thinking, right? But let me turn back to you for a moment, Tony, and ask you an initial question. Why would you say it's important to have diverse patent attorneys to interface directly with inventors during the patenting process?
So this is actually a follow-on to something I believe that Holly had said during her presentation about trust levels and speaking with someone who looks similar to you. And so, as you know, I'm of South Indian descent, and obviously my parents are from South India, and a lot of the inventors I deal with, are first generation Indians. And I noticed this with my parents when I was growing up, but I never knew what exactly was going on. But with some, not all first generation immigrants, but with some first generation immigrants, it's almost like they occupied this chasm. And what I mean is that, here's India, here's the United States, then here's that chasm. So, like take my folks, for example, they're kind of viewed upon differently in India now because they're like, well, you kind of abandoned us and went to the United States. And then, in the US, I don't need to get into that, what happens there or here. So they're just in the middle there. And and then and I've seen this firsthand. So now they're like doing a disclosure meeting, and then they see someone like me come on the phone or come on the call. And I've seen it happen many times where, a lot of us know what foreign filing licenses are. So I got to ask the question about citizenship. And then that's like raw, in my opinion, with so many issues. And then I'll preface it, say, look, I'm Indian descent, and I have to ask this question. And I can just tell, like, the inventors just become more relaxed and they become more comfortable. And it's been kind of weird because then what ends up happening is, I'll take the disclosure and, we'll move on. And then 6 months later, they'll reach out directly to me and say, hey, I've got this idea. And it always gets me into trouble because in-house counsel is like, no, they can't be reaching out to you. They have to go through us. But, I think it's following to what Holly had said about, they just feel more comfortable. And I think it runs the gamut. I mean, not just, South Asians. I think it runs, across all lines. And, I think, especially listening to what, has been said today, I think it's a way, to draw more, people of color and, women. I think it's a way to draw them out and have them more comfortable with the patenting process because they're like, okay, I'm not a lone shark here. There's others that look like me. And, I just think I just think it eases the comfort level.
Yeah, I mean, you've got people reaching out who, but for those initial conversations, they wouldn't be reaching out at all. So, Kara, here's sort of like a boots on the ground type of a question. STEM achievers, many of the folk who are participating in the programs that you guys put together, they have typically already invested a great deal of time and money to become competent in their specific fields. And now, the challenge is how do you convince them that further investment, specifically in IP training, will benefit their individual careers?
I really like this question because I definitely did not mean to suggest that all patent attorneys were working with things falling out of the sky and were incompetent in their fields. And most of our programs really are aimed at the best of the best in their engineering fields or in their STEM, mathematics, hard science. I don't think convincing is necessarily the goal, right? We don't need to convince anybody that they need a career path. If they're happy where they are, if they're going to be fantastic in academia, that's where we want them to stay. We need innovators. We don't need everybody to become a patent attorney. Our goal is to spread the awareness so people can make an educated decision for themselves and what's best for them. And, I think this goes back to my story of maybe I would have been a bad engineer. We'll never know because I was in the right place at the right time and heard about a different opportunity that I thought would be right for me. And so I think our goal is taking the investment they've already made and giving them an option of, is this what's truly right for you, or are you looking to continue to achieve on top of it? because it's not a full transition. I think what was especially appealing to me going into patent law was you're not wasting all the time and effort that you've already put into an engineering degree. Look, you're already qualified to take the patent bar. You just need a little bit more here. And again, we're not trying to lure people away from the profession that they're made for. If people want to go into engineering, we need those people, and we need diverse people in those fields as well. This is just an alternative that we want to make sure people are aware of, and make sure that we're getting people to leverage their best selves in the way that's right for them and that benefits all of us.
You know, it becomes it becomes so clear that for various groups in our society, and not just ethnic groups, racial groups, geographic regions, uh, what's possible, what's available to you, it's presented in a very narrow spectrum, right? And it's sort of like, okay, so you live here in Appalachia, you're going to go into the coal mine, right? Okay. You are in Watts, you're going to do music, right? Okay. And basically, what you guys are demonstrating is that why limit the potential of individuals? What you guys are presenting to them is that, well, have you thought about this? Okay. Or if you've thought about this, like some of the inventors that you've spoken with, but you never thought you could take it anywhere, right? You're seeing, and so we're really picking up on some of the things that were discussed this morning, some of the challenges, and that you guys are specifically meeting those challenges for those individuals who otherwise would just not have those opportunities. While we're waiting, somebody question, I got one more for Derek, and then that's it. We're just gonna start looking at you, all right? And shame you into asking questions. Successful IP commercialization and entrepreneurship requires a convergence of multiple resources. You could tell that one was written by a law professor. IP acquisition and enforcement, capital investment, effective market access. How do you persuade your audience that for them, this is all doable?
Yeah, that's a good question because when I chat with founders, that's usually the topic of discussion, right? So in the life sciences, it's a very expensive field, so I'll be very clear about that. But if you look around, you're sitting in seats. Likely these seats were patented at some point. You look at your phone. There's so many technologies that have been patented. Wherever you go, there's innovation everywhere. At some point, it was new and it was novel and it was inventive. So it's been done before, and at times done by folks with less resources than you have currently. So why not you? That's really the question. Whenever I chat with inventors, it's always a question of, what's the path forward and what will this cost in the end? You don't really know because there's so many twists and turns on the journey. Some drug products, they take 20 years to get through to approval. Others take 6. Some are blockbusters, some are not. You chat with a founder, likely they'll know that 9 out of 10 companies will fail, right? So these are all things that are circling around. And I've never met a founder that said that this is easy. It's always difficult. You chat with them, they're like, oh my goodness, the life of a founder, right? And you sympathize, but you know what they're trying to do is to move something forward that'll be benefiting the rest of us. And that drives them. But they do understand that this is difficult. And I've definitely met a lot of folks who want to be part-time entrepreneurs. It doesn't usually work out very well because of the time commitment that it requires, right? So you got to go full in into doing it because, again, I work in the life sciences, so typically you're talking about VCs investing in, and if someone's about to give you $50 million with regard to a project you're working on, they want you to be fully invested in it. Again, they understand the risk that they're about to take, and so should you, and usually you do. So companies will fail, yes, but why not you as far as the success that will be on the other side? High risk, high reward, typically. So it's all possible. Long, hard road, but certain things aren't easy. Doesn't mean that you should not do it.
One of the things that strikes me about your various initiatives is that they're all available, access to them online. So what this really means is that if there are folks out there in the audience, as a matter of fact, let me ask the audience a question. How many of you can think about individuals that you know, whether they are students, high school, college, law school, graduate school, people out there working, people who are currently experts in STEM fields? How many of you can know any people, and you can just do this by raising your hand, that you think could benefit from one or more of these initiatives? Okay, and do you have initiatives, let's exclude these guys for the moment, that before today that you would have pointed them to? Okay, so about a third of the audience have initiatives, which means that the rest of you know people who could benefit from these initiatives. And until this particular moment, or until today's conference, you would not have known where to point them. Okay, so certainly, even if you don't want to raise your hand and ask a question right now, these guys, you need their information because you can actually send people to them, because that's one of the other purposes of this conference. We don't necessarily need people to go out and replicate what you've done in another part of the country, replicate your program in another part of the country. What we need is to say, okay, if we've got it, we don't need to reinvent the wheel. Okay, now let's start lifting it up and making certain that access is made available to people all over the country. While you guys are getting over your shyness and trying to come up with a question, I have a question that I can toss out to all three of you guys. And that's, can each of you think about a particular sort of exemplary example? Somebody who came through your initiative that, by the time they got through the end of the process, oh, wait, great, we've got a question. So let me get your question first. Yeah.
Often what Jeremiah heard is like only big companies with big resources could do this kind of research initiative. So I'd love to hear more about the backstory, how you all convinced your partners or leaders that this was important to dedicate time and resource to all of these initiatives now you've made. So.
Okay. That's a great question, actually. And for us, it was more like a time commitment. And what I mean is that, there's various, as you know, there's various aspects of patent law. An example is like continuations. So, for this portion that was geared towards law students, we had someone just discuss continuations, like what they are, when you would use them, when you wouldn't use them. And it's for the biggest commitment for SLW Academy was the time. We kind of, and we had to buy cameras because I would say about 50% of the lawyers in the firm are remote. I'm based out of North Carolina, so they had to send the hardware, but that's a nominal cost. But really, it was more a time commitment, and I think what it is that I have personal reasons for, being involved with this, and everyone I know, had personal reasons. Maybe a family member was, part of a marginalized community or something like that. So it wasn't really forced, and one thing I neglected to say is that we also have like paralegals and docketing clerks that also did it. And it was one of these things where people just jumped on board. And I think it may have been a little easier for us because, as I mentioned, we're not ground zero, but pretty close to ground zero for, what happened in the spring of 2020. Everything just blew up. And, I think a lot of people are like, yeah, we've got to figure something out here. And then if you go online, if you go on our academy, it's not just people who look like me or Kara or Derek. It's like everyone did it. And it's actually a nice cross section, but it wasn't, fine. We have billable hours and all that. So, there's that. but it wasn't really, I didn't really think it was too much of a, it didn't seem like it was too much of a commitment, if that makes sense. But it's, everything was in-house, so it's a lot easier to defer the cost, if that makes sense.
So I'll give a not firm pre-approved answer here, you guys. And I think there's kind of two schools of thought to answer your question. There's the answer I would like to give you, which is it is the right thing to do. So you need to find the time and the space and the money to do it. And I'm fortunate enough to work at a place where there are people high enough up that we have that this is the right thing to do attitude. Everyone doesn't buy into that, right? So to your question, how do you justify it to the people who don't buy into the we need to do the diversity initiatives for diversity's sake and because it's the right thing to do and to make ourselves better? There's always a business reason. And I'm so grateful to hear people like Jeremiah up here speaking about how important it is to corporations to have diverse outside counsel and to have a diverse inventor base. Because that is really the driving reason, I think, behind a lot of law firms having these initiatives. Clients expect to see it and you need to do it. And so there's my answer of I love to staff diverse teams and I want the pipeline behind us to be able to do that going forward. It's especially nice when clients want that as well. And that gives you the business reason to do it as well.
I can just add something about the Finnegan involvement, because Finnegan has been working with us at Howard from the inception of that 22-year-old program. And it's because the higher ups there, people like Esther Lim, who a lot of us here know, and Tom Irving, when he was still at the firm, he's since retired, they just made the decision. And there's for those of you who've been at our program, I have this little anecdote that I tell as to how it came about. And just as your situation grew out of an adverse set of circumstances in 2020, ours, the partnership with Finnegan, it grew out of 9/11. And we, Tom and I had not known Tom yet, we were to do the All Ohio CLE program, which is in 2 different cities. And, you fly out there and then you fly to the next city. But of course, all the planes were grounded, right? And so they were able to get like something going a few weeks later to get us to Ohio, but then to get from Cleveland to Cincinnati, and, they hired a bus. And, it wasn't a Greyhound bus. It was a cool bus, right? With a bar and everything like that. And we're all together, talking and eating dinner and what have you. And Tom and I just started talking about the need for this type of effort. And out of that, we just mapped out on this bus ride, well, why don't we do a CLE program that focuses on cutting edge, developments in IP, but let's incorporate social justice, diversity recruitment, et cetera, et cetera. And it was the first program of its kind back in 2003. And it is still, we've not missed a year, and it's done nothing but grow. And so what you're saying about having the folks at the top also buy in, I can attest that at Finnegan, that is in fact what actually occurred. Darren?
Yeah, so I absolutely agree with everything that's been said, because there's definitely the time pressures, the cost pressures, and the right thing to do. I'll give the example as far as how I happen to be in this chair right now. I think Margot was doing a presentation, and I don't know how it got in my inbox, but I'm on K Street and open my inbox. Like, that sounds interesting. I have an hour. I could walk over, so I walked over to the presentation, and then afterwards we started having a conversation, and she noted that there's this event. And I was like, oh, I've never heard of this event. So I went back to the office, sent some emails around, and it was approved, right? So you do need folks in positions where you could get certain things approved and certain things moving. And as a partner at a firm, where your interest is in, directing resources to a certain place, that carries weight, right? And yes, I mean, I'm at this event, my computer is over there, and I'm sure there's tons of things flowing in that I'll need to address, but it's also what's important to you as well, right? Of course, you need to do the client work, get things done on time. But there's other things that are just as important, and this is one of them. So at Wilson, definitely there's folks like myself who come across different events or initiatives that you get together and you want to do, and the firm is very much supportive of that, and they put the resources behind it.
So one question I have is a lot of the things you've been talking about are from like law school and undergrad. So what if you're kind of hiring mid-level associates and you want to make sure that that pool is diverse?
So are you talking more so about retention, or
if you're hiring a second or third year level and you want to make sure that that pool that you're going to be hiring from has diverse candidates in it?
Yeah, I think if all these programs work according to the way that they should, you should have a pool, right? Because once you get to a law firm, folks move around, right? And you imagine that if that pipeline is working the way that it should and the way that we want it to, you will have diverse folks moving around as well, right? And every law firm is very much cognizant of the numbers, right? You don't necessarily want to be one of the firms called out for looking at a partnership class or whatever it may be, right? You want to get quality folks, and you want to get folks that represents your clients and the population that you're serving, right? So that's always there. Important bit is that qualified, right? So the fact that you're black or that you're a woman, it's not necessarily like, okay, I'm going to hire someone because they're black. No. You hire someone because they're qualified. They just happen to be black, right? Or they happen to be a woman. But I think all firms are looking at it from that perspective. And also the hiring committees are, at least at Wilson, it's made up of different folks from different communities, to ensure that there's, less as possible bias in that respect. So you get that diverse view on any one individual that's interviewing.
Yeah, I'll add to that, all law firms are out looking for diverse lateral candidates right now. And not that anyone's going out looking for a particular demographic. Everybody wants the best person for the job. But there is value, right, in boosting those numbers of diverse and attorneys from underrepresented minority groups. One thing that we do that I think is effective is having a mind towards retention from the initial lateral hire particularly, right? You don't want somebody to show up feeling when they walk in the door like I'm just a diversity hire and now I'm here and they're checking a box because I'm here and in 2 years I'll have to move on to somewhere else. So really putting the effort in on the front end with lateral candidates generally, but particularly lateral candidates from underrepresented minority groups, to say you're not just a number on a page for us. You are an attorney and you're here because of who you are and the potential that you have, and really making sure that you build a network around them and you don't just throw them, into the ranks and here you go, you're here on day one. Best of luck finding work from the partnership. None of that, but really showing the investment will not only help get them in the door, but make sure that they stay long term.
And as a follow-on to what Derek Carr said, I think, that's a kind of a slippery slope. But, I've worked in plenty of firms where, a candidate, come in like, a person of color or female. And, I'm sitting in this room and then the candidate walks out and we're just sitting there talking about it. And they just start saying offensive things. And I'm thinking to myself, do you know who you're talking to? And I point that out because like in and where I'm going with that is that it's viewed as a negative. So I don't know if it's the right thing to say, oh, we actively recruit from this group. The In my mind, at least, the better way to say it is that we don't hold that as a negative because, as I mentioned, I'm from North Carolina and there's a lot of grumblings in the patent world over there in Raleigh about how it's, how the network works over there, and I've seen it. And, that's really what the perspective is. And then not only that, it's like, at SLW, firm leadership, one of the firm leaders is also Indian. And I remember thinking to myself when I was interviewing, I'm looking at this guy and I'm thinking to myself, this is someone who looks exactly like me. I'm going to do everything within my power. I don't even care if I'm going to have to take a pay cut. Don't care. I'm going to do my best to, to get in here. And, it's not a negative, I guess. I mean, could I say it's a positive? Sure. But it's not something that's going to be held against you because I know it's still out there. I mean, I know for a fact it's still out there. And, to answer your question, I guess it's a non sequitur in a way, but that's really how we would approach it.
And I guess one final thought on that, and it may be a good note upon which to close since we're pretty much out of time, is that I think that for firms that are looking to do exactly what you have identified, one way to assist them is to make certain that those firms, really as many firms as possible, are aware of these types of initiatives. Because one of the things that can happen is that when you're out there and you're looking for candidates, I mean, let's face it, if you want people from diverse backgrounds, in some cases, you just have to look at the person and see, okay? But when you see that they have initiatives like these on their resume, right, it gives you an additional confirmation, right? And so what can begin to happen is that to the extent that we can make firms aware of all of these initiatives, then firms can start tracking it, right? They can start looking at these initiatives, see the success rates, see where many of the graduates of these initiatives go, right? And that might be another project, for us to start looking at, see, this happens every time at this conference, right? Colleen is shaking her head. We come with initiatives, and by the time that we end, we leave and we say, hey, you know what? We got another thing to do. So maybe we should all start tracking what's happening with these folk. And then the success of those folk, it will get other firms looking at them and saying, I want somebody from SLW, Finnegan, Wilson Sonsini Academy, because I know that those folks are winners. I think we're out of time. Yeah. So with that, please join me in thanking our excellent panelists.
Really great job putting all of this together.
You guys are easy.
Very nice meeting you. Great working with you. Right here in the stuff, yeah.
How long are you guys in town for?
I'm lucky and I live here, so.
Oh, yeah. That's right. What kind of people in the room? I think right after. I was 6 point highway, something I didn't know for.
Gotta get out. It's particularly bad because Emory sits so far from the main highways that take to the airport. It can be a little bit rough just getting to the highway from. Yeah.
Oh, no, I'm just introducing. I'm Margot's stand-in for just to introduce you guys. Yeah.
Come on, man. How you gonna just say hi? Because you never know. But yeah, I went to you actually were there when the name switched back to the My wife's in the post office. Okay. I got to go to the big house.
Nope, nope, we're good.
Yeah. I understand why.
We just need Braxton. This is Braxton gets here.
Stadium now is bigger than, but it is good thing. Actually, the 3 years I undergrad, actually lived right on the Hanover. I was there just to work out, play ball with the Central Campus Rec building in Michigan. And the first were to tear down the rink.
Yeah, as soon as Braxton gets here, we can get going. We can't start without him.
Yeah. That was great. The law school was down all this week. It's a great area. Students living in an area that they can't afford to go. But I got to Evanston. For the crowd, ask questions or will it be straight?
I think you guys can straight chat because we don't have that much time. But you know, it's up to you. What you want to do. But we definitely want to hear from you guys. But we do need Braxton.
Don't come.
Oh, here he is. He got the pink jacket, so. All right, we're about to get started. All right. So we are so excited about this fireside chat between two extraordinary innovation leaders, moderated by an innovation empowering visionary. So I want to go ahead and give you a little bit of background on who you're going to be hearing from because it's a really impressive group and we're really excited to hear them in conversation. So to begin with, we are fortunate to have with us today the Honorable Derek Brent, Deputy Undersecretary of Commerce for IP and the Deputy Director of the U.S. Patent and Trademark Office. As Deputy Director, he serves as the Principal Advisor to Kathy Vidal, Undersecretary of Commerce for Intellectual Property and Director of the USPTO, managing a wide portfolio of programs and operations for one of the largest IP offices in the world, with more than 13,000 employees and an annual budget of more than $4 billion. His responsibilities include working with Director Vidal to lead the USPTO, advance IP policy and procedures, expand the USPTO's outreach efforts to incentivize and support more innovation and entrepreneurship nationwide, and execute the agency's policies, priorities, and programs. He has, before this, also served in the other branches of federal government as well as the private sector. For 6 years as a senior trial attorney at the U.S. Department of Justice, Civil Rights Division, and also chief counsel in the U.S. Senate, where he handled IP issues among other topics. He also worked in the private sector, serving as vice president and associate general counsel at Massimo, on the leadership team at Cut Golf, and as an engineer at GM. He received a BS in mechanical engineering from The Ohio State University and a JD from Northwestern University School of Law. And he's going to be in conversation with Donald Bremer, Donnie, who serves as Atlanta's first senior technology advisor. And in this innovative position, he serves as the mayor's chief liaison with the local tech sector and assists with shaping policy and programs. He also works with Invest Atlanta to attract new companies to the city, grow existing ones, and advise the administration on fostering Atlanta's technology workforce. He's been instrumental in helping identify the location of the new Southwestern USPTO regional office, which I think we're all excited to know more about. Prior to joining the city, Donnie was the general manager of Lot Vision Automotive at Cox 2M, a division of Cox Communication, and was responsible for the product roadmap and strategy for their flagship vehicle tracking and telematics platform. He's also worked at BlackRock. But importantly, he's also himself an Atlanta entrepreneur, leveraging the mature team that created and deployed a successful automated bartending system in numerous entertainment venues. So we might hear a little bit more about that. Now he studied economics as a Division I student athlete at the Georgia Institute of Technology and also earned an MBA at the Wharton School of UPenn. Their conversation will be moderated by Braxton Davis, who serves as Associate General Counsel at Facebook Meta and is a co-organizer of the conference today. Thank you so much to Meta and Braxton for your participation in the conference. A true visionary and force in the IP and innovation space, Braxton earned an undergraduate degree in physics and EE from Morehouse College and Georgia Tech, respectively, before getting his JD at Georgia State University. He began his career in patent law with the AT&T IP patent development and innovation team, and was later named partner at the Amin, Turosi, and Watson patent law firm. He's a creator of opportunities for others. He founded the Patent Institute of Training and Patent Pipeline Program, whose graduates will be celebrating this evening. And that program teaches promising engineers how to become successful patent agents and entrepreneurs. He's also devised and established the National Council on Patent Practicum, which I hope we hear more about. It's a nonprofit that focuses on increasing quality and diversity within the patent profession. And additionally, like Braxton, like Donnie, Braxton is a tech entrepreneur. He founded a tech startup, MetricMate, a mobile platform for tracking workouts and performance data. So we couldn't really have a better panel of people to talk about innovation and tech in Atlanta, and also sort of more with respect to thinking about national initiatives as well. So let me turn it over now to Braxton to go ahead and take us away.
Thank you. Thank you. First, I'd like to say, just thank you for allowing me to be here. I am definitely, elated to be sitting next to two panelists such as Donnie and Derek. Fun fact, Donnie and I actually attended Georgia Tech together. He was an athlete. I was a nerd. He was the cool one. But, we somehow found our way out. So I can appreciate him sitting here today. But yes, thank you all for being here. And today we want to talk about tech and USPTO. And have a really lighthearted discussion as well. But, these, like I say, I'm elated to sit here next to these two gentlemen who have done phenomenal things in their career, and onward and upward. With that being said, we'll toss the first question to Derek, which is, how do you envision the new USPTO hub in Atlanta positively impacting diverse inventors in the region, and what specific initiatives are planned to support that?
Thank you very much, and it's always a pleasure to be with you, Braxton. I've got to watch some of Braxton's great work, and in fact, one of my very first events that I did was USIPA, and I got to watch Jeremiah, who's here, Michael Binns, and Braxton tear down the house discussing what they were doing. And when I say tear down the house, I mean, the place erupted. It was just a level of excitement. So you're one of the people that inspires me to keep on going and keep finding ways to open doors. So I appreciate it. And another thing I want to say, just as we talk about opening doors, Donnie, I am utterly impressed by the work that you've done in just a short time in your position. I firmly believe that the ACES program that you have here is going to be one of the a model and one of the most important programs for improving innovation around our country. It is a syndicate, it is a collaboration, but it is going to scale innovation in this wonderful city. I also like the fact that you crowdsource innovation through the innovation ideation portal. What you're doing here in Atlanta is exciting, which is why we are happy to put an office here. And I also don't want to leave out my friends at Rice at the Russell Center for Entrepreneurship and Dr. Herring and her wonderful work with Propel. You are all doing amazing work here in Atlanta. So the short answer is that's why we're here. And we're here because we have resources that we believe can help this area as well as the region. Atlanta is trying to fulfill its promise. So when we looked around and saw a place that we could put resources and get force multiplication, but also get great feedback on the ground of what's going on, this was a great choice. So what will we be doing? We will be doing enhanced outreach. We will be doing outreach throughout the region. And by the way, this region, just to let you know, Atlanta certainly is booming, to use a colloquial term. But you have a lot going on in the region that's going to be covered by this office. Tennessee and North Carolina both have started consortiums that will help to support commercialization, research commercialization, moving tech transfer. And I know that's something that's being developed here, but the legislatures in North Carolina and Tennessee have moved it into reality, and now they're in the program of building a system that can help other schools that are emerging in the tech transfer space to start to grow, so that those schools can take the research that already exists and help move it to the market until those schools can develop a program. So you've got that. Florida has the high tech corridor that has been successful. There is a lot going on in this region. We will bring outreach. We will bring subject matter experts. We will also be pulling on you for everything in this region that you have for your feedback in terms of helping us, because we have a lot of programs and policy that we will be working and developing, that we continue to develop. And heaven forbid I mention those two beautiful words, or those two beautiful letters, AI, that is dominating the conversation right now. And we're doing a lot on AI, but I can get to that later. But that's why we're here.
Thank you, Derek. Thank you. The next question is going to be for Donnie. And the question is, as Atlanta's first senior technology advisor, what steps are you taking to foster a more inclusive tech ecosystem? And how might these efforts intersect with the goals of the USPTO, as Derek mentioned?
Oh, one thing I want to address, because he made this call out about me being a jock at Georgia Tech. And if you're at Georgia Tech, you're a nerd. Everybody's a nerd. So there's levels to it.
There's levels to it.
But and the second thing, I'm disappointed. We have prizes for everyone in the front row, but there's only one person in the front row. So we'll address that. But those look like students in the back. I don't know why you all are so far away.
Hey, those are my students. Come on up.
Well, either way, yeah, like come so close right now, like Jordan Hewitt said. But either way, no, excited to be here. Thank you for giving me the stage, and it's great to be with you both. And also, I'm excited to hear that you looked into ACES. And so what ACES is, he mentioned this consortium we started in Atlanta. And what it does, it brings together Emory, Georgia Tech, Spelman, Morehouse, Clark, Morehouse School of Medicine, Georgia State, all the schools across the center of the city to try to increase collaboration of the students, of the faculty. And so that way, the next time there's a unicorn startup out of Atlanta, it's not four nerds from Georgia Tech. Right? And so you've got a sales guy from Morehouse, a policy person from State, a lawyer from Emory. And so with that diversity of thought and perspective, you'll have better products, better outcomes. We're also working to bring down resources for the ecosystem and share them between the schools. And then lastly, the last stated goal is to make Atlanta a top 5 tech hub. So when you're looking to start something, you don't move to San Francisco or New York, you can do it here. And the other, I guess the fine print I'll call out around that is to do it equitably. Because what you've seen in Seattle or Austin, oftentimes when the economy grows aggressively, many of the people from the city are left behind. And we already have wealth disparities in Atlanta that we're trying to address. So we see technology as a pathway to close some of those gaps. And so when you talk about inclusivity, there's 4 different categories of talent that we look at trying to reach. It's K-12, you got to start when you're young, introduce them early. University, mid-career, so if we can move people from working at Home Depot to spinning off to build something. And then lastly, trying to build a skilled technical workforce for people that may not have a 4-year degree or sort of fell out of the pipeline somewhere. How do we take them from driving Uber to working at Google or Meta? And so we've done a lot of work there, paying for different certification programs. Or one of the things I'm really excited about on the inclusive front for K-12, has anybody seen Dukes of Hazzard? Y'all seen that show? Right. So it's great. So this is, I'm from Charlotte. So my first introduction to Georgia was Dukes of Hazzard. And so but did you know the poorest census tract in Georgia is not Hazard County, it's in Atlanta. And so there's a neighborhood called Thomasville Heights, and there's a Parks and Rec Center that we put an esports lab in. And so what we did is created a space where 60 young people every week come and game. And it's a safe space, but it also introduces them to programming and design and different careers that you can take on in that space, as well as esports, so broadcast and production. And so all these careers that they never considered, but it's attached to something they already do, because like 90% of people game. So this is a way to meet people where they are in the sense that it's something you already do, but also physically removing the barriers because it's in your neighborhood. So,
can I add one thing on top? And Donnie hit on it a bit, and that is that when you think of innovation, a lot of people think of technology or gadgets or different things, and but innovation occurs across a wide range. And I know, Donnie, you go out and speak to entrepreneurs of all stripes around town, and that's one of the things that the Atlanta ecosystem has. Is it has this from a mom and pop shop all the way up through the highest level technical invention. And we have to continue to think about entrepreneurship broadly in terms of how people are developing small businesses. And that's part of what the Atlanta ecosystem is doing. That's how you create more inclusion.
You call out a good point. So we're going to go off script because it's an interesting thought, because you see this bifurcation of small business or lifestyle companies and then sort of venture backable deep tech startups. And we over index in the former just because, especially when you talk about people of color, they're often not coming from a 4-year degree or a technical background, and they're solving problems that are close to them, right? So I couldn't find a hair care product for my son or something or whatever the case may be. So I created a company around it. And so we want to find those operators, those builders, and then pair them with some of the opportunities and bigger problems. So if you've built a great restaurant, you might be able to also run a tech company. And so with all of the IP that's available through these tech transfer programs and from those little 3-letter agencies across the government, so we're trying to find ways to, through ACEs, programs where you're pooling talent from schools and you've got people with a propensity to build a company, take them and pair them with some of these solutions that are primed to go and succeed. So.
And to those lifestyle companies and all those the smaller entrepreneurs, listen, intellectual property is very important. Protecting your name, because you don't know what comes next. Maybe you go from the digital space direct to consumer. Maybe you move into an actual retail slot. Maybe you move to franchising. But all along the way, never forget, intellectual property is not just patents. It's also trademarks, it's copyright, it's trade secrets, it's the whole ball game. So, and part of our resource that we will put here will put an emphasis on letting people of all entrepreneurs of all kinds know that about intellectual property that applies to their business. In fact, we have a thing called the IP identifier, which is on our website at uspto.gov. We have it's IP identifier. You put in a few answers to questions, and you get an idea right off the bat of what type of IP might apply. So it gets you a start. It gets you ahead of the game.
That's awesome. This panel is moderating itself, so I'm just sitting here. You know, and I'm fine with that. I'm fine with that. So essentially, they've touched on the next two questions inherently. And one of the things that I do like that you mentioned, Derek, is that, it's not just patents. And as a patent attorney, sometimes we do tend to over-index on is it patentable, right? But I can really appreciate what you're saying in the system that you mentioned about putting in a few questions or terms and it deciphering kind of what intellectual property you might need, because you'll be surprised at how many questions I get from someone that'll just say, "I have this great name, this great slogan. How can I patent it?" Like, well, it's not really a patent. And so I think those types of tools are great for individuals and smaller inventors and what have you. But could you share just a little bit about what initiatives or outreach efforts you have for these individuals as well?
Sure. Well, one of our primary areas or vehicles for our outreach are our regional offices, which are all around the country. I'm happy to see my good friend and colleague and the man that taught me how to fold a suit to put it into a suitcase. Mr. James Wilson is here. James is one of the great ones. And he knows he has bat phone privileges with me. That means that whenever he calls, I answer. So, but our regional offices do a wonderful job, and I'm gonna call James out a little bit because he did a wonderful job in expanding outreach in the Midwest region over the last year plus to get to more places. The most important thing we're all trying to do, is to find innovators and creators everywhere. And so in order to do that, you have to put resources where they are. You have to go find the people and bring them into the system. The regional offices do a tremendous job. They hustle. They're like at the end of a wind sprint. They're exhausted, but then after they tug on their shorts and catch their breath, they go and they do it again. So I'm always happy to stand beside them and try to help out any way I can. We have other resources that we also use. We have our trademarks team does a lot of research outreach on their own. We have the national strategy for inclusive innovation, which we may hit on a little bit at different places. But we just issued that this past April. And it's a great strategy because it comes from our Council for Inclusive Innovation, which is a group of private sector, federal government, and academics that are all coming together to answer the question of how can we move things forward in terms of creating more innovation. And this strategy is one of the ways, and what we will spend the next year doing is turning those recommendations, like you said, K through 12. How do we get the secondary level? How do we get more opportunities? Preview, I happen to think that tech transfer is one of the best opportunities we have already at HBCUs and at all schools. We in the Atlanta area and other areas, we are producing high levels of people in STEM. We have to give them the opportunity to go out and to do research, and then to take that research into commercialization. So that's another tool that we have. So we do education and we do policy making, but those are some of the resources that we have. And we do a lot of engagement. In fact, I'll close out by saying this, and with our regional offices over the last year, and James will call me out if I'm wrong, but I believe, James, we're north of 65% of our outreach is going towards small businesses, individual inventors, universities. And that's big because that's creating the future pipeline. And if you look at the pro bono program that we run, we're seeing results on the other side of that, where we're increasing the inclusion in the innovation pipeline.
Thank you, Derek. Donnie, could you share some upcoming initiatives or projects in Atlanta that could enhance innovation and support diverse entrepreneurs, particularly regarding access to capital?
So access to capital. I'll call out something that's actually special, because I think he knows, but we had this program we started for startups. It's called the Atlanta Growth Loan Program. And what we wanted to do, because it's really hard to raise money in Atlanta or anywhere else, is put dollars into startups' hands. And so The loans are 3% interest max. You know, even with the rate cut, that's still competitive. You can't get that anywhere else. 5 years to pay us back. No payments for this first 6 months. And Braxton, he's a founder, and we actually gave his company one of our loans. And so, congratulations. That's a big deal, right?
Thank you. Thank you.
And so we carved out about $2 million. He didn't get it because we know each other. That's not how it operates. But we're really proud to have found a way to help entrepreneurs during a difficult time. And so that's a perfect example. We've got probably 13 companies across varying industries, founders of all sorts. So.
Yep, and just as an aside, since Donnie brought it up, I am a tech found up starter, Metric Mate, and it is you think you obviously have patents, right? I had to do that. We have trademarks, we have viable. It's not even a minimal viable product. It's a functioning technology. You can purchase it on Amazon. You can purchase it off our website. We have a mobile app, in Android and iOS.
This is an ad. Download it now.
Shameless plug, right? But I say all that to say that what I've seen in trying to raise capital as a small startup is that even with all of that, like there's still questions about, well, we really don't know how well this is going to work, and being revenue generating, right? But I've also seen our non-minority counterparts go out with just the idea, and raise millions of dollars in capital. Well, I have this idea, and if we do blah, 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 just an idea. And so I say that from the perspective of a startup founder, and that it is difficult for underrepresented communities to actually gain access to capital. So I appreciate what Donnie's doing. I appreciate what Derek is doing as well. But it's this whole ecosystem that we have to kind of lean in on, because if we don't do it, no one will.
Can I add just a real quick thing on top of that? First of all, I mentioned CI squared, and I'd be remiss if I didn't recognize the person that led the efforts over the last year plus, Ms. Valencia Martin Wallace. Thank you. Thank you. I do the same thing when I see her. I clap, stand and clap. But she's part of that genesis. There's a great stat that McKinsey put out about the opportunity gap, and it is that, of course, we all know the stat that roughly, Black entrepreneurs receive about 2% of all funding for small businesses. But if you could raise that to just representative levels, for census, 12% or so, you would add $1 trillion to the GDP in gross revenues, and that's irrespective of performance. That's irrespective of performance just by their existence. So that's the opportunity gap that exists. But when you have programs that, like yours, that bring that funding to folks and give them that start, that's moving somebody from where they want to be in the system to where they're in the system. And by the way, it's okay to fail, get up and do it again. The other thing we have at the USPTO, where we address this, was Director Vidal started a program called We. And every Wednesday, every second Wednesday or third Wednesday of the month, she ran a program, or she was running a program. We're still doing it. We're just not doing it monthly now. But where we brought women, it was women entrepreneurs. That's what We stands for. And what we did was we brought funders, funders from the federal government, from the private sector, as well as women entrepreneurs to talk about their journey. And we have had tremendous success with that. We've had tremendous engagement. In fact, Director Vidal tells a story that one woman drove, I think, 3 hours just to be there because she wanted to thank the director because she had received her patent, which helped her to start her business, which was successful. So bringing the funding into the realm is very, very important. And so I applaud you for that effort.
Yeah, it's cool. We have a We too. Like, we as the city of Atlanta have a women's entrepreneurship initiative, which is the only
trademark.
I don't know. I guess not. It seems like everybody's got one. But so it's the only municipally funded accelerator for women entrepreneurs in the U.S. And I think having these intentional purpose-built programs, so there's We for women, there's the Russell Center for Black businesses specifically, and Jay Bailey, who leads the Russell Center, he's got this great story of a family from Canada. They drove down because they heard about the Russell Center, and they says, if I'm going to create this, I need to go there to get the support that I need. So they piled up in a sedan, the wife, husband, and 2 kids, and drove all the way just to be at one of the info sessions for the Russell Center. So I hope they let them in. I don't know the story beyond that. But the myth is that when you have these types of spaces that are dedicated to a certain subgroup, you'll find that you can be more successful by that intentionality.
Thank you. Thank you.
Oh, one thing, poll the room. I just want to know who we're talking to, so as we respond to his questions, we can say things that are relevant. So how many of you are lawyers? Most of the firm, okay. Any students? And then anything I missed? I felt like most of the hands. Okay, got it. Okay.
Hallelujah.
Mm.
Okay. All right. So we have about 5 minutes left. Do you want to take Q&A, or do you want to Q&A?
Sure. All right, any questions? Well, yeah, I've got some. So we're actively trying to address that with ACEs. And so Georgia Tech, they have a pretty mature office, and they've actually, oh, okay. So you know the Office of Commercialization and SEVA and all those. And so we want to take the things that they're doing well. And Emory, they just sort of invested Wilbur Lamb. He's growing out the function here. So all the best practices we want to try to pass to these other schools that are in the MACE, sort of ACEs consortium. But you may have something that's.
First of all, I love if we could connect, because I want to get your ideas. You've been in the private sector, and you've also been there. I would love to hear more about your thoughts. And I know my friend Grant Warner is back there, knows that I'm passionate about this.
Oh yeah, you got to talk to him.
Yeah, exactly.
He's the person that can fix it.
Definitely talk to Grant. The short answer is, I think part of what I mentioned in that states getting behind it, states and cities getting behind it. So ACES is great as a local. I think I would love to see the state of Georgia and other states think about consortiums. And I always point to this one consortium. Kentucky Commercial Ventures has done more to lift tech transfer in Kentucky for the schools that don't have the offices. Like you said, it takes a lot to build an office. So while they have the research but not the office, you can have a consortium that takes that load off of the school while they're developing some revenue. We also have to win more of the minds and hearts, particularly at HBCUs. It's a world of limited resources. So we have to win the minds and hearts of the administrators so that they're willing to take that bet on the research and taking it out to the commercialization stage, because only 1 in 5 startups ever make it through. So that's a hard bet to make. And every time when you're an HBCU and you get $1 in the door, you're thinking, hey, I can either help another student come in, or I can fund this program that has a 1 in 5 chance. And quite honestly, we want them to make at least more of these bets. So we have to do more outreach. And then, as another friend of mine in the room, Suzanne, knows, work to bring the market closer to the research so that there is more of a product market fit. Once you have that product market fit, now your research goes to the marketplace, and you have a better chance of licensing and/or spinning out a startup.
Thank you, guys. Let's give our panelists a round of applause.
Thank you so much. We could definitely have had more time, and I hope we will continue the conversations in the breaks and then also at the reception after. But now we're going to be transitioning into our 2 tracks. So if you want to be here listening to a set of conversations about promoting diversity and excellence in the patent profession, stay in this room. The academic track will move to the 5th floor, G575, and we'll get started in about 5 minutes. So look forward to seeing you guys in the tracks. Thank you guys so much. Timing is tight. I know. Keep going.
Um, Everybody, we are about, I've been told we need to begin. Um, I didn't realize, I didn't realize I was on point moderating, so I'll pass these down. Well, thank you guys for being here. Thank you for coming to this panel session. Thank you for supporting what we're doing NCPP with the patent pipeline program and the certified patent practitioner credential. And so we'll just get right into it since we're running kind of behind on time. But I'll start from my right to left and let our panelists, our esteemed panelists, introduce themselves. And we'll take it from there.
Great. Can you hear me? Great. I'm Greg Kirsch, and I think I'm looking up here. I think they switched our names between Kian and myself. They flipped it around, but no problem. I did a little double take there, like, wait, that doesn't look like me. So I'm Greg Kirsch. I'm a patent attorney. Been practicing patent law for about 34 years, both in DC and also in Atlanta for the last 32 years. And I'm a partner at Smith, Gambrell & Russell, a law firm here in Atlanta. I head up our our IP practice. We've got about 40 IP attorneys in our various offices around the country and also in Europe. And my background is, just very quickly, my background is electrical computer engineering, and my patent practice focuses mostly on software, computer technology, communication technology, et cetera. I'm also, oh, by the way, I'm also an adjunct professor at this fine institution at Emory Law. I've been teaching a patent class here for about 27 years. So,
Lindsay?
Thank you. Good to be here. So I think Colleen did a pretty great job for me about introducing me and my current job. So I'll just give you a little bit of my background, where I do have my degrees are in electrical engineering and physics from Xavier and Howard University and HU. All right. Any Xavier in the house? Anything? Thank you. So I was working in an engineering company for about 3 years before I decided to go to law school, went right there to GW. So of course I decided, why don't I just go to the USPTO, get my 3 or 4 years of experience to make me competitive in a firm. And by the time I graduated law school, I knew it was my place. 32 years later, here I am. So.
Well, my name is Kean DiCarlo. I'm that guy in the corner. Oh, they did. God help us. In any case, I've known Greg for, wow, a long time, since I started as an attorney. We used to be partners in IP Boutique, Needle and Rosenberg. Known Brandon for a long time. He was a student of mine. I'm an adjunct professor at GSU and Mercer University. Been teaching IP-related courses for decades now. I'm a partner with Womblebon Dickinson in our Atlanta office in Greenville. Womblebon Dickinson, I think we have about 250 people practicing just in IP in the thing. So that's both domestically and internationally. A lot of experience in this space, a lot of experience trying to expose individuals to that, and try to be very, very supportive of getting people actively involved and trained to do this work. We've got a challenging environment in front of us in terms of technology, but the skill sets that people we have here and are being trained here will go a long way toward managing yourself in a very challenging future.
Thank you. Thank you all. Let's give our panelists a round of applause. Because, what they've accomplished, as Kean mentioned, he was my former professor. I've known Greg for years. I've known Valencia since 2019 when we had our first NCPP inaugural meeting. Many of you might remember that. And, I stand on the backs of these individuals who've paved the way for me. And we're here trying to do that same for the newer generation, right? So I'll start with that. And I want to say that we're here today to discuss promoting diversity and excellence in the patent profession. And if you know anything about the National Council on Patent Practicum, you know that our 2 pillars are diversity and quality, right? And we lean really heavy into those pillars. And those are the things that we are looking to continue to support as we grow and develop our programming. So with that, we'll get into the questions. And this question is for everyone on the panel, but it's, in what specific ways have you observed AI technology transforming the patent landscape? And what are the key challenges and opportunities this transformation presents for the certified patent practitioners and patent examiners?
Well, it's transformational. I mean, there's no question that AI across many, many disciplines, not just law, not just patent law, but it is transformational. We've seen lots of different waves of these kinds of transformations over the years. The .com era. We saw, now we're seeing AI kind of have an impact, and it's great, but it's also bad. It's possible to have something be both bad and good at the same time, because it creates all kinds of new tools. I mean, look, when I first started practicing law back in the late 80s, early 90s, word processors were still fairly new. And when word processing came along, that was huge. It transformed lots of industries, including the legal field. This is, equally, probably even more transformational, but with the good comes the bad. And, like any tool, you have to know how to use it, because, tools by themselves aren't going to do much without somebody that knows how to use it and knows how to use it well and knows the negatives that it might, contain. I mean, we've all heard the news about, lawyers filing briefs using AI tools where they, the AI spits out, made up cases, that don't even exist and nobody's checking. I look at AI tools in general, whether it's patent drafting, whether it's any kind of legal or any kind of application. I look at it as maybe an inexperienced associate or young patent agent who's just entering the field. I look at the output from AI in a similar vein. It's like trust but verify, so to speak. You have to kind of know what you're doing and how to use it. You need to know how to prompt it, and it has tremendous potential. I mean, I'm 59. I'll be turning 60 in March, and I just need a good, another good 5 or 10 years ahead of me before I retire. But people who are younger in this field, it's going to be even more transformational for you than it is for somebody like me a little bit, later in my career. And, I don't think it's taking over. I don't think, it's eliminating our jobs, but I think 10, 20 years from now, who knows? It will. And so you really have to know how to master it. You need to know how to use it effectively, but also you need to know the downsides and the risks, because there are significant risks.
Yeah, I agree completely. There are amazing advantages and there are amazing drawbacks to where AI is today. And it's going to have huge advancements. Just look at where we were 5 years ago with AI and how much it's advanced. But in looking at the use of it in the IP space and specifically in patent examination, we are making great strides in areas of search and looking at informalities as an application first comes in. But it's exactly what you said. Being able to have a search done through AI and having prior art sitting there on a docket for an examiner is fantastic if you can trust the results. And how do you identify whether those results, not only are the results accurate, but also just putting a piece of prior art in front of an examiner tells them nothing unless you have some information about the description, about the how it identifies with the inventive step, the things that an examiner is going to have to do if they go out and do that search themselves. So efficiencies are great as long as the efficiencies are there. But putting something in front of an examiner where you've just identified a few text words or an image, and therefore it's put as a piece of prior art, is going to cause that examiner to have to go back in and do a lot of work to be able to reconcile why this prior art is valid. So a big piece of it is, yes, we're making great strides. We're doing great things in search, in informality areas, in the classification areas, but aligning that and who's going to be that human, the intellectual look at it to identify what's right, and then feed that back into the system. And until, we have true AI where they're doing it, this machine is doing it all for themselves, that intellectual touch is going to have to be there.
Yeah, again, kind of echo where we're at here. The interesting part is it's time. How many people here have used AI to draft a patent application? Right, right. So the interesting part about it is you see limited number of hands on that. Part of that I know is firm driven, because I certainly am a large firm. So talk about fearful about misstepping, privacy, confidentiality. There's a host of issues on it. And I think probably smaller firms are going to be a little more agile on that. And there could be some advantages on small to medium-sized firms responding to the benefits of using AI. But a lot of people who initially dabbled in this were using public databases to do that, which is not the place to be if you're drafting a confidential document, right? Now there's tools out there that are being developed that are sophisticated enough that they can be used. Right now, I think the confidence level is much higher on users for the patent search, patent analytics. They can certainly drive things. So certainly knowing and being able to have it do a much more effective search that hones down, that's beyond a Boolean character type search, is beneficial. Patent analytics to be able to serve clients is a bigger leap now, where they actually can map out fields, potentially find areas of opportunity that they can direct or try to draft patent claims toward. So there's benefits in that space. We're finding tech transfer offices are wanting that data from us. Large corporate clients are wanting that data. They want to know where the clear space is, where the patent space is, where they can move in to. If they're doing deals, they're using a lot of AI, because you can identify claim sets to do very discrete analysis of claims. That's say, oh, we'd infringe this, we need to license this, or find beneficial third parties that they may be able to generate license revenue from. Those are pretty easy snapshots, right? Patent drafting is a whole different beast, right? What we're still finding out is there's a large criticality involved with the individual, the person drafting the patent, most primarily drafting the claims. That's an art form to a degree. All those of you that have done this for years, you appreciate the nuance, the thought that goes into crafting a claim set that can, one, meet the client's needs, be legally boundary, and meet any requirement at the USPTO. Doing that is still going to be there. I've yet to see, and we've been experimenting with a lot of these, a piece of software that does a good job of drafting claims. They may help in kind of analyzing them thereafter, but the software that's involved now really is derivative of that. Once it gets claims on there and you've got a good set of claims, the software that exists now that are discrete AI does a pretty good job of aiding you in drafting spec and that kind of thing, because that's more rule bound and it can do that. But I absolutely agree with Greg on this. It is imperative to check everything, right? You would treat something that's generated from this as if it were done by, 1L, 2L, somewhere in that space that's, okay, I'm going to check this, I'm going to analyze this. If there's any sites or whatnot, you're really going into rigorous look on that. Part of that we're going to talk about is also large firms and whatnot. If you're using your internal databases, bias control, all that kind of stuff, firms don't have that structure right now built, right? They're having to implement that and create experts inside. I will throw out this though. Young people, individuals in this profession, you want an edge? Become an expert on AI in this space. It will generate a premium for you in both your career advancement and potentially remunerative to your wallet as well.
I agree with that, Keen. For the newer generation, you have to figure out how to incorporate AI into your day-to-day life. That's where it's going to be. And to Greg's point, depending on where you are in your career, that may determine how in-depth you get with it, right? But I think for newer practitioners, for the PPP students from this year, and past 2 years, this is going to be your future, right? And so you have to start thinking about these things now, and how you want to incorporate that into your future and your educational processes and professional processes from this point forward. With that, Valencia, the next question is for you, which is, how has AI changed the international landscape of patent examination, and what quality control measures are being implemented there?
So great question. So I think in the last few years, the global IP community has really started to open up and embrace AI and working together. On the utilization side of the tools, we've done a lot of work on image and text searching and making sure that we're trying to harmonize that, as well as with the classification system. We're moving into AI of classifying the technologies as they come in, which is imperative as we're working from, while we have about 45 countries who are working through CPC, but we also have to harmonize that with IPC, with the F classification at JPO, and making sure that as each of the individual IPOs are really delving into AI for classification, that we're working together to make sure that we are using the same set of training data in order to, especially with emerging technologies, make sure that we're classifying in alignment with each other. With the search as well, that it really is the training data. We can't do that in our own little square, our own little sandbox. If we don't do it, it's the same thing with any type of patent examination or the policy. If we're not sharing information, if we're not discussing it and harmonizing, then the system is just going to go crazy. And you have to have a certain level of consistency in order to make sure that your clients are getting a strong patent from one country to the next, and the inconsistencies are there. So we're working really hard, which with working with the other offices to make sure that we are sharing as much data as possible to get there, both policy side as well as utilizing the resource tools. And it's sometimes easy, you know, when we're working through maybe some of the trilateral, which is Japan, Europe, and the USPTO, as well as the IP5, and adding in Korea. I'm not going to speak for China on making sure that we're sharing data. But that's the biggest struggle, is making sure that the IPOs are talking to each other as they're making these advancements. Another area that we're trying to work together on is global assignment, and how do we utilize AI in order to make that more efficient, especially when there are different laws in each of the different countries on how to collect that assignment data. So while we're definitely globally have a more open communication, it's still quite a challenge, a long way to go.
Thank you, thank you. So Greg and Keen, what are some best practices that you would recommend for integrating AI technologies into patent drafting and prosecution workflows while still ensuring that the quality standards are maintained at a high level?
I'll take a first crack at that. I think the biggest issue, and this has been said kind of in a different way already, but is understand what AI can do, what it can't do, because it's very good, as we've discussed before. These AI tools are very good about, you know, at distilling information, summarizing, even comparing inventions to prior art. I've been amazed at what can be done with these AI tools. Very, very impressive stuff, and in a very, you know, succinct, very nuanced way. Very, very good at that. What AI is not good at, and this is kind of how we look at it in our own workflow at my firm, it's not yet, you know, now maybe this will change 5, 10 years from now, but it's not yet very good at the business nuance. You know, we as patent practitioners, we can file patent applications for our clients. We could, you know, get office action, respond to those, amend claims, arguments, you know, et cetera, and get a patent issued. But of course, you know, patents are only as good as what they protect. And, you know, I've seen situations, I'm sure we all have, where, you know, somebody is prosecuting a patent and they kind of lose sight of the, you know, of what it is they're trying to accomplish by, you know, creating value for their client. And they lose sight of what's important to the client. You know, what kind of protection is key. You might add that additional limitation and you say, yes, you know, the patent examiner has agreed with me. You know, the patent will be granted, only to realize that by adding that one limitation to the claim, you've narrowed the claim in a way that makes it completely worthless to the client based on the marketplace, based on the client's competitors, based on what is going to be valuable now, what's going to be valuable 5 years from now. So AI is not yet good at that kind of thing. That's where, you know, skilled patent attorneys, patent agents, coupled with their clients, with business people that kind of understand the marketplace, understand the industry, what's important, what's not, that's where that comes into play. So you have to be very careful not to rely on it as a crutch for that kind of nuance, because it's not going to help you there. It may help you 5, 10 years from now as it evolves, but we're not quite there yet. One other thing, and then I'll let Ken talk as well, but you know, client confidentiality. Not all AI tools are equal. You know, we're all familiar with ChatGPT, there's Perplexity, there's Gemini from Google. There's all these platforms. Some of them are consumer facing, some aren't. They're all very impressive, you know, in their own way. But I would never, and we forbid our attorneys and our patent agents at my firm to use ChatGPT, Gemini, Perplexity, or those kinds of systems, because they're not confidential. You know, I don't think anybody's read all the terms and conditions, but if you're putting information about your client's invention in there, who knows where it's going to end up. Now, there are tools out there that are. Like I've used Solve Intelligence. I don't know if anybody's familiar with this platform. It's a West Coast platform, very, very powerful stuff that helps you draft patent applications. And it is set up so that the training data that's used subsequently is not, you know, what you just entered in a prompt previously. And so they you know, demarcate what can be, you know, used and what can't be used. And I think most vendors now that are playing in this space that have tools that we as patent practitioners can use, they're very aware of this and they're very careful how the data that you're entering is being used or not. But that's something that you really need to understand before you start typing stuff or digitizing and inserting your client's invention disclosure into ChatGPT, only to find out that who knows what OpenAI is going to do with that information later. So got to be very careful with the tools you use. Ken?
And that's very interesting, ChatGPT. I said I've had friends that, yeah, I've done that. I said, you do realize that's now public disclosure. So forget about international filings. Forget about you just gave that away. So the risk is out there. People are a little more nuanced now and can appreciate that. But yeah, we have the same rule of nothing public. If you have any questions, we've identified very particular people in our firm, come to these people who will be able to tell you what you can and can't use. Because we're the ones that are actually going through and looking at the software, vetting the software. This is what we're going to have for the firm. Be frank, we're still working through that because it's an ongoing developing thing. This is best. It's not like you want 10 platforms. It gets expensive when you have a large seat cost for that. But we're vetting through that to be able to get the right platforms for our firm to be able to use on there. Things we're worrying about. Large clients or very specific clients have say, large bank. Banks have their own rules, what you can and can't share. That's going to be one of those where the training data set now and in the future is theirs, right? It's not shared. You're not blending that over. Other clients may want to use their own isolated thing, but how you train it, how it's being used, all that is being, in our firm, being vetted right now to try to find the best players on it. And I would say really in the last 6 months to a year, we've actually started seeing platforms come out that you can look at and go, yes, I feel good about the security. They're being very conscious about that, what you can get. There are platforms out there that you have a much higher confidence level in using on it. We use those. We're in a process of vetting through in that process. Some of the things we're worrying about, be it built-in bias conditions, privacy, some of the things we'll probably talk about later in the thing, but managing those, how you do that, how you vet. So it's not one of these things where because it's evolving, the rules are evolving from the firm on it. But what we found is the best way to do it is create a structured environment where everyone knows this is what you're going to be using, and then everyone's getting trained, right? It's not like they're just being thrown, use this. No, they're being trained and worked through. And for all intents and purposes, you're holding their hand for a period of time because people need that to be able to walk through and do that. Those of you that are of the very younger generation here are at just extreme advantage here. You've grown up with computers. Your comfort level with a computer is crazy, right? So this is just a new thing, a new play toy. Treat it as that, but become expert in it, okay? I firmly believe 5 years from now, you're going to be the ones in the firm driving this bus, and the partners at that level and above are going to be coming to you with questions. How can I do this? And they're going to be looking for you to be answers. Okay, so there's an opportunity for you to grow rapidly with your firm by becoming expert in this, in something that's natural to your talents.
Thank you, Keen. So you bring up a very good point around data privacy and bias. And so this next question is for the entire panel here, and it has to do with what do you believe what are the ethical considerations that practitioners should take into account when utilizing AI, and particularly in relation to data privacy and bias?
Go ahead.
Thank you, thank you. So it is imperative that we take a great deal of consideration as to the privacy and the bias. And I think everything that was said on this panel and that Greg and Keen just brought up again is exactly what we need to look at, right? So your algorithm is only as good as the information that goes into it. And if that information is flawed due to biases or a lack of transparency, then what you'll get out will be less than par, less than what you're looking for. So it gets back to what was mentioned earlier. It's the human is the validator of everything coming out. And I would say, in the spirit of the diversity as well as quality, it's a combination of the two, right? The algorithm that's built, the data sets that are built are only as good as the diversity of the team that's building them. And if you don't have that level of diversity, I don't care what the action or initiative is, if it's, making sure that you're building the right strategy for a client, or is making sure that you are building the right application or background information on the particular idea. If you don't have a diverse team that can help you look at all the different aspects and build the right solution, you're not going to find the right solution. And that goes very far with these systems that are out there and who built them, and making sure that you can rely on what's coming out of it, which is exactly what you were saying. And I'm glad to hear that you're seeing better quality and security. But we have a long way to go with that. And one of the things that I just want to mention to everyone, if it's something that you have not really looked into, I won't go into great detail, but just go through a few items from President Biden's executive order on guiding principles in AI and what should be addressed. I'll go really quickly. Safety and security, responsible, innovative, competitive awareness and collaboration, support of American workers, advancement of equity and civil rights, protection of AI users, protection of consumer rights, risk management and governance, and technological innovation and progress are all things that you should be considering as we're moving into AI and the systems that are being used. And please go on to the site. You can find the executive order and get more detail on it.
Thank you, Valencia.
So we've talked about bias, how that works. One of the things, realize both the USPTO and our bar association you have a duty of candor, right? You got to be, basically, you're not telling fib. You're not feeling, here's my inventive case. Here's my inventive X. So it has to be accurate. What you're saying has to be accurate. Depending on AI, because it's AI, for the sake of just saying it's AI, is not intelligent, because it will make mistakes. Think of it as an 8th grader in certain respects. It needs to be checked, it needs to be updated, and how do you address that? One of the ways we're doing it is we actually now have a subsect committee that has to meet. Right now we're doing it quarterly, but it's probably going to go to a monthly. If there's a statutory change, if there's a major case that's come through, whether it's trademarks, patents, anything in the field, we are addressing that, right? Because we need to ensure that any training sets that are being used, any data that's being used, updates those accordingly. That way, at least you address the thing of, we cited this, there was this case, so I've always used that case. Well, that case isn't good anymore. And you just represented it to the USPTO falsely. You may have thought it was right because the AI did it right, but it's wrong and you didn't catch it. So it's a way of trying to catch those errors. And it's critical that the firms do that, have these kind of built-in controls set, because you and I all know 3 or 5 years down the road, you're going to be so dependent on this, you're not going to see it anymore. You're not going to be looking at that. You're going to be looking at the arguments, see if that meets your needs. But citations and whatnot, you're going to be highly dependent upon this AI to get it right. So the firm setting up controls to try to catch these is critical.
Let me just add one extra thing here. You know, and this kind of goes into the overall theme of this conference, diversity, and I've seen this play out. You know, whether it's AI or whether it's law firm life, but I've seen situations where like young associates or patent agents at a law firm have been worked under the tutelage of like one partner, and that's all they've ever done. They've just been assigned to one partner. That's all they've learned. And that partner may be a great partner, and he or she may have had some good experience. But when you're learning just from one person as opposed to a diversity of people, you kind of have one way of thinking, and you may not see the full picture because you're not kind of seeing the different diverse views that other partners might bring to it, or different ways of looking at things or solving problems. The same thing can be said for AI and using these kind of tools. If the training set is not diverse enough, you're garbage in, garbage out. You're going to get crappy results as a result, and that applies to the world at large. Diverse opinions, diverse backgrounds. We've all heard about how that affects situations, and it ends up you get suboptimal output. And so just from a pure practical application, the more diversity, the better, whether it's, among people of different backgrounds, whether it's associates or people working in a law firm or a corporate setting or the U.S. Patent Office or wherever, or whether it's training data that's being used, and so, just one last thing, I think it's been said before, but, as you explore these AI tools, don't just assume they're all the same, because they aren't, and they all train differently. And you need the same kind of diversity of thought that you have in an organization. You need the same kind of diversity of training with your AI tools.
That's where there's a somewhat advantage in the medium to large scale firms, because typically they have a larger bench of data that they can incorporate in here that encompasses, so you almost inherently get more diversity in there. That can be good and bad to a degree. But valid point on that. How to diversify that is huge, and that skill set translates well.
Yep. No, I couldn't agree as well. And one of the things that we actually try and teach our patent pipeline program students is there's understanding the fundamentals of patent prep and process, but then there's also stylistics, right? It's Keen is going to draft differently than Greg may draft, right? And not only that how they draft could be predicated by what their clients want. Like Meta wants certain words in their applications, AT&T might not, and things of that nature. X can do Y, X may do Y, right? Like these little nuances. And so what they're essentially saying is that if the AI is not being trained on that level of diversity, then it's not going to output applications at that level of quality. So with that being said, transitioning into quality, Greg, Keen, how do you believe that the certified patent practitioner credential enhances the assessment of proficiency in patent drafting and prosecution, particularly in comparison to traditional qualifications?
Well, I'll just jump in here. The U.S. Patent Office does an admirable job with the patent bar examination and has been doing that for many decades. But I think, and it does a great job of kind of measuring kind of the baseline of, understanding the MPEP and understanding claims and et cetera. But I think the CPP has a very important role to play to, kind of be that extra certification to test for different, perhaps more advanced aspects of patent practice. And I think that's still evolving, but everything that I've seen and been involved in myself, I've enjoyed my involvement with the NCPP over the years. Um, it's taking it to the next level, and so I think it has an important role to play, especially as we talked about, with AI, with all these different changes, with the changing landscape of jurisprudence that we see from the courts, with patent eligibility under 101, with different ways that the courts are interpreting patent laws in general. To stay on top of that, I think you need this extra certification and extra measurement to know who knows their stuff and who doesn't. And so I think CPP plays a very important role in that. And but it doesn't supplant the the patent bar, of course, but it adds another layer to that to ensure that when somebody hires somebody with that CPP credential, then they know what they're getting, and they know that that they're getting that extra expertise that others may not have.
Curious, how many people took the patent bar when you started to do the claim section? Okay, as you can see, very few. Yeah, the old folks. Okay, so back, yeah,
Seasoned.
yes, seasoned. I'm going to just say old. It worked for me. In any case, back in time, the requirement that the USPTO did was the same thing where what's your knowledge of patent law, statutorily, et cetera. And then you came back for the next day, and guess what? You get to draft claims, right? So when you received a passing grade from the USPTO at that time on the patent bar, it certified you as both having knowledge, statutory knowledge of the patent law, but also some skill set in drafting claims, okay? Now it's just statutory. There's nothing that says you don't even know what a patent claim looks like, right? So it's very, if I'm going to hire someone, somebody with this credential that we're talking about goes a long way, because that tells me a couple things. One, that beyond just pure statutory understanding, they have an understanding of nuance of how to apply that. Again, some of the testing that's involved for getting this credential. And they've demonstrated that they can both write claims that are passing, let's say, but also statutory or writing a spec. So they have a skill set that goes beyond, right? So having that just for someone to hire is huge, okay? Realize the test here isn't just this, can you do basics? It tests nuance. It's expecting somebody at probably the 3, 4, 5-year experience level. Everybody in here that's practiced for a period of time knew what a fire hose it was for the first year or 2 or 3, right? Your learning curve is steep on what you're learning and how to draft applications, how to respond to office actions, what are the arguments, what are the nuance of application of the law. That stays the same, right? So what you're testing is that person at that level, right? If the person can pass the test, who has that kind of training skill set, what you're then saying to the rest of the world is, look, this is a very qualified individual, whatever level they're at in their career, they're very qualified to do the work, right? So whether you're a supervisor amongst your peers or whatnot, it is a credential. I think over time it's going to go a long way in differentiating the individual in the marketplace.
Yeah, and I'll add to that as well, Keen. Here's a very likely scenario, right? If we look at, I'll take myself for example. So Braxton, 2007, I took the patent bar. Lots of studying, MPEP, passed on the first try, knew, 35 USC 103, back and forth, all these things, right? leave the test, get my registration number. You couldn't tell me I didn't know patent law, right? But I had never seen an actual office action. I had never seen a 35 USC 103 response in real life, right? Even in law school to a certain extent, I did not see those things, right? But if you look at my name in the registration, in the database, USPTO database, it sat right there next to Greg and Keen's name, who had years and years of experience. So, typical scenario. We had some small inventors in here earlier. Some may still be in here. Oh, I see Braxton, he's newly minted patent agent. Let me look him up, see if he can maybe draft a patent for me. 2024 Braxton has AI. 2024 Braxton says, yeah, I could put this in AI, draft some claims, draft a spec, and then you run into all those issues, unbeknownst to you, that Greg and Keen and Valencia have been talking about earlier. Ethics, candor, public disclosure, essentially malpractice. Very likely scenario, right? And so I'm saying those things to say that that's why the CPP credential is going to have more relevance even now, is because we have this tool called AI, and it's effectively giving newer individuals the opportunity to use the calculator without knowing how to do core math. And that's never a good deal. So Nick, well said. Oh, thank you. Next question, Valencia. What quality-based initiatives has the USPTO implemented recently to address patent examination quality concerns, both internally and externally?
Great question. So one of the things just with the AI theme that I'll talk about really quickly is through our pre-examination process, we do use AI to look at specification, abstracts, drawings, to look for any informalities and make sure that the examiner does not have to spend their time on that, as well as giving that level of understanding to applicant as to, okay, don't let the simple things trip you up. So we've done a lot there. We don't have anything in place yet, but we're also developing AI systems to look for 112Bs as well as functional language. Will not go out until we can rely on the results of it, but it is an area where we feel that those are the quick wins for examiners if we can right up front have that there for them. So doing that, as for some other quality, we've done a lot with both internal and external developing examples, one-on-one examples. Of course, there's never going to be enough examples to get through the one-on-one issues that are raised in advanced technologies and pharmaceuticals at this point, but we are building on as many as we can find, building on them, training the examiners, and then also releasing those publicly through our webpage to try and help bridge that gap. We also have a program that I'm really proud of called STEP, which is a program, it's a 3-day program. During the pandemic, of course, we had to go virtual, but we're trying to get back to in-person. And the whole focus on that STEP program is bringing newer attorneys in for 3 days and sending them through the examination process, what a patent examiner goes through. Go through each of the statutes, go through all of the policies, the processes, answer any questions. It's a pretty intense 3 days. And we've had a lot of success with law firms saying, yeah, you need to talk to my new guy. We'll send them through the process because it's teaching the attorney from our point of view what we see when you submit the application. So that's been a huge, for us, quality improvement for both the examiner as well as the attorney, because that's what has to happen. The quality has to go up on both sides in order for us to get the effectiveness, the efficiency, the reliability of the granted patent.
That sounds great, Valencia. So I had the opportunity. So looking back at my personal story, I couldn't get a job at a firm's 2009, 2010, 2010 recession. people had their job offers rescinded, right? And so I had to find things to do. And one of those things was, applying for and entering the USPTO externship program, which I'm truly grateful for, even though I didn't receive credit for it, wasn't paid. But what it did for me in those 10 weeks at the USPTO is give me the knowledge of what examiners go through. And I still remember being at the Patent Training Academy and going through all those things. And that's very important. And that gets back to actually a conversation that James and I had this morning. And I saw it actually in person at the USPTO. There's this one attorney who came in for a trial, at PTAB, and there was no deference. It was almost like he was talking down to the examiners. And it's like, you win more, what's the phrase? You win more bees with honey type of deal. It's like some attorneys go into this with the idea that they are somehow better than the examiners, right? And we talked to James about that, and it doesn't have to be. It's not adversarial. It's like when I would have an interview with an examiner on this side, it's like, hey, we're both trying to help promote technology, help promote innovation. Where do you see some holes in this argument? Where do you see that we possibly have, leverage for an allowance? And like it got to one point where I kept running the same examiner. We're talking about family and vacations and all these other things. So that program that you mentioned, I think is very, very important for the newer practitioners, because it is something that is lacking in sometimes the mindset of attorneys, where they think that just because they're an attorney, they are better than at some points.
A lot of those people are thinking it's an adversarial relationship. Like, okay, I'm against you, so I'm going to be a jerk. I have no, and really you just kind of see this different thing. Realize the examiner is a gatekeeper, right? They got the keys. Be nice to the gatekeeper. Make them happy. It makes things work so much better.
It's that human touch as well. I mean, I remember, pre-pandemic when we interview a lot of cases. It's almost every case we interview. It really helps, to meet with the examiner. But post-pandemic, it's all done virtually. But we always insist. They don't always abide by it, but we always insist on a video interview, with Teams, because you just can't, via phone call, you just don't get the same thing across. And having that human interaction makes all the difference.
Yeah.
We were talking about this before. The interesting part about post-pandemic, I don't know whether it was a skill set that developed with people with comfort level about doing these kind of video calls, and I have the same experience you do. It's all video now. Is technology's improved to such a degree that you can really help. People are comfortable with it. Video goes a long way. As we alluded to in our conversation, one practice note you could always throw up for the interviews, if you have documents, papers, or whatnot that you want to discuss, make sure they have them in their hands physically before the interview. Don't waste this, because you have a brief interview period. Don't waste the time on a technical glitch going, I can't get you, I can't show. Make sure they have all the things up there. They get an opportunity to do that, because an interview is a huge opportunity to positively move the case forward, give both sides here an opportunity to get input into it, so you can get claims issued that create value for your client.
And that's one of the things that we talked about is, for an examiner, one of the greatest frustrations is a practitioner asking for an interview, and when asked, can you please provide me with an agenda or your topics, and get nothing. And now the examiner has to walk into that interview only understanding from their own point of view why this rejection was made, and having no understanding, and then having all of about 40 to 45 minutes of a discussion, and then asked to make a decision on it. You're not gonna get that decision.
Help them help you.
Exactly.
Moral of the story is interview your cases and submit agendas prior to the interview. That was standard operating procedure when I was at the firm. The one thing I will say, and I hope the PPP candidates hear this, if I could create the perfect student, here's what they would have. They would have the patent prosecution experience that we already provide. They would have patent litigation experience as well. We teach them patent litigation. They'd also have USPTO patent examination experience. and corporate patent strategy experience. If you find a person with all of those things, or at least having some semblance of knowledge of those, they're going to go so far in just this profession in general. Like, you're touching almost everything. So to the students out there and those aspiring to get in the profession, try your best to get those experiences. Like I said, I was fortunate enough to participate in the USPTO externship. That gave me the examination experiences. I had some patent litigation, light experiences in law school, but not really anything heavy. You get more litigation experience in just general litigation, not necessarily patents, but it was something. And then working for AT&T as a patent examiner, patent developer, that gave me more of the corporate IP stance, right? So I implore you to seek out those opportunities and put yourselves in position to gain those types of experiences as well.
I found the interesting part, I didn't have the examiner experience on there, but all you, especially if the younger attorneys, while you can, if you're a patent prosecutor primarily, drive into the litigation section. Make sure you're working with them. When your billable rate's low, work with the litigators on that. The best prosecutors I found were people that prosecuted and did some litigation, because the litigators know how to poke holes in claims and specs, all that. Once you start identifying that, being able to translate that and learn into your work goes a long way. Okay, the best litigators also had patent prosecution experience for the same reason. And I would, my corporate background was that MBA goes a long way to understanding business speak and goals of business, and being able to then translate that into technology and patent.
And I'll tell you, during my law school interviews after going to the USPTO, that was the first thing on interviews that the attorneys wanted to talk to me about. How's your experience at the USPTO? What was that like? Because the majority of patent attorneys have never gone to the practice at the USPTO before, right? So there's this like, oh, well, that's cool. Like, what can you tell us? So there's inherent value add with just that alone. So once again, USPTO is definitely a great option to really diversify and round out your skill set.
I'll just add one more thing here to that conversation. I would say think really hard about what Braxton said, right? When he wasn't finding the doors open to him, he went out and creatively figured out how to get it done. So yes, so I would look at him as a model for, if it doesn't happen for you immediately, what can you do to make it happen? And just keep going.
Okay. Thank you, Valencia. But as again, I say that I've stood on these guys' backs. These were my role models in law school and trying to figure it out. So great individuals to know. I implore all of you to meet everybody up here on this panel and get to know them and their background as well. And the patent community, IP community is very small. You're gonna run, you're gonna run in a very, very small circle. So you want your reputation to precede you in a positive manner, but you want to know people who can help open those doors for you at different junctures in your professional career, right? And that's how I've just been able to be this successful, is just these relationships that are over a decade old, right? Do the same thing. It's not just about being able to do the work itself, but you have to get out there and network and build those relationships and make sure that you know that you have, a support system and people to call when you have questions about certain things. And I hope that's what this program is providing for you guys.
Don't hesitate to ask us. Why would you do? I'm walking in there as a young associate or young agent, whatnot. First step, second step, third step. How do you progress your career? We're more than happy to talk to you about pathways, opportunities that we've seen that have been successful. We can give you some horror stories too, and where we see this practice going. The good thing is, despite there's been a lot of AI here, guess what? Your skill set can't be replicated. You're still going to need your intellect, and the nuance you bring to a problem. That's still going to be out there. Your skill set is going to be, I would say, if not as, it's probably going to be valued even more into the future.
Another thing I'll say too is that, and I know that this has happened, but how many of the PPP alumni are actually calling or texting or emailing their old professors when they have questions about office action responses, strategy, prosecution, and things of that nature? Now, I've seen it happen before. Leverage those relationships. You know, we're a community. We're here to help you out as well. And I know that it's happened with particular students, but I want to encourage the rest of you as well, and anyone in here to continue to do those things. That no matter what point you are in your career, relationship development is just key. So with that, we've finished the majority of the questions, but I can leave it open for Q&A if anybody, if you guys don't mind. Caden. And who are you again?
AI, I think we touched on it before, but I think it's the over reliance. I think is the biggest concern. I think people relying on it more than they should is my biggest fear. That whether it's a young associate or whether it's me or anybody, that know its limits. Know it's a tool, and just like any tool, whether it's a drill or a saw or AI, it can be dangerous if not used properly. So know its limits. I guess maybe career-wise, someday, somewhere, maybe AI will take over. Not like a horror movie, but like it will do things that we normally do on a day-to-day basis. But I think even then, whenever there's been a technological advancement over the years, there's always been doom and gloom. Well, it's gonna put people out of business. There's no, we're not gonna have any workers anymore because it's all done by machine or robots. And I think that's, maybe more so now than ever, but I don't think it's ever going to be the case. I think, every new innovation is created new opportunities. When machines started replacing, human labor for manufacturing, all of a sudden, new types of jobs popped up. The technicians that maintain the machines, the engineers who design the machines. So there's always kind of the silver lining to any innovation. I don't know. I mean, even with AI, there's this new concept of prompt engineering. How do you know how to prompt the AI to do what you want it to do? That's a science unto itself. They're teaching these, colleges and universities now are teaching these kind of classes on prompt engineering. So I think the risk is and the danger is know the tool, know its limits, and just make sure that you as a person are evolving to take advantage of the tools as it evolves, because otherwise you're gonna, put yourself out of a job if you're not keeping up.
I would say it's almost twofold. I would say one of it is, I use this when I'm talking to clients. If you want a service provider, somebody's just going to get you a patent, I can give you some great people to send you to. But if you want a business partner, I'm your man. Because that means knowing your business, knowing your values, knowing your goals, and then how to translate that, your technology, into something that actually provides value in the way your company wants to do that. I still think AI is going to have a very, very difficult time of making that leap, right? It can do, these kind of rule-based things well, but that's not rule-based. That's nuanced thinking, okay? So I think the risk becomes on that is the work becomes devalued, right? Where people say, oh, it's just a patent. I'm going to give you this thing and you're going to plug it in and there's a patent. If companies start doing that, then they're going to get patents of that value, right? That are going to be probably readily defeated in litigation, whatnot. Do I expect there's to be a cycle of that'll do that because the cost value is there? Yes, but guess where that's going to stop? When that company gets hammered on a significant technology and litigation. At which point I'm going, I don't care what we're doing, we're not doing that anymore. We need to create higher value patents. So I think it's the risk I see out there is this kind of overhyped AI can do all, right? And then that begets into almost commoditized price points driving back down for providers such as ourselves. That basically you can't provide the nuanced work you once were because there's no profit in doing that. And I think it's a bad cycle that a lot of companies are going to have to go through. They're going to learn the hard way that a patent for patent's sake is valueless unless it meets the company's business need. And that's a lesson they're going to have to learn.
So no discussions around providing it within the MPEP. I think there's still a lot that needs to be addressed, a lot that needs to be discussed. I know we've put out some guidance and we have quite a few sessions for feedback from the public on the use of AI and the policy surrounding it. But as of yet, no, we're not putting anything out through the MPEP. But I would suggest that you go onto our website when we are having listening sessions, because we do want to hear from our stakeholders on AI policy as well as the use of resource tools.
So I think we have time for one more question. I believe I saw a hand back here. Ethan.
Yeah, it's a great question because when you start searching for prior art, then of course you need to handle it carefully, and if it needs to be disclosed, you have to disclose it to the patent office under the duty of candor. So we do it. It depends on exactly what we're doing and how we're doing it. But if it's returning results that appear material to us, and we are cognizant of that, then we will we'll track it down. We'll do screenshots. We'll make note of it, and we'll submit it as needed. And that's something that benefits our client, of course. The more the better prior art that's considered by the examiner at the patent office, the higher quality your patent becomes. So it's, you know, it's in everybody's best interest to do so, and it's of course required by Rule 56. But yeah, we will we'll make note of it and we'll disclose it.
The interesting part about that is, it really is. This is something that AI does pretty well. Patent searching, it does pretty well on going in there. But it's highly dependent on what the information you give it. So you're actually trying to give it, it's not just a generalized search, right? It has to be a much more nuanced search where the points you believe are points of novelty are included in that search parameter. Another reason why it has to be private, right? And not using public resources on it. The good part about that, when you do that, you get it does a very good job very quickly of giving you a group of references, okay? We don't do anything other, I mean, we'll analyze them and whatnot, but that group that thing prints out, that's what's being sent in. I don't want to sit there ever in the thing kind of go, well, you printed out 20 and you only submitted 10. Oh, no, here's 20. I'll let the USPTO discriminate against it. It definitely is a case of garbage in, garbage out. If I've done a good job of providing the question, we found you get very, very good results from it. And in places and some references you probably would never have found, okay? The litigators are using this a lot because this also does a very good job of drilling down claims. Infringing, non-infringing, invalidating art, whatnot. It's I would say AI, because that becomes very rule-based, is very good at drilling through claim structures like that, giving very good results.
Well, we have to wrap up. Thank you to our panelists. Round of applause, please.
Yeah, by the way, it's good to see the USPTO doing things like initial categorization. That's like a perfect use area. Oh yeah, initial categorization. It probably I bet it does a better job. It doesn't really. At this point, but that seems like a tailor-made application for AI. Yeah.
Racial.
Yeah.
Levels of technology. So we'll send it through the system.
Oh, I see. It's almost like it's doing too much. It's doing too comprehensive.
Yeah.
Yeah, I
So,
can see that.
the progress on what's called the C-star, right? It's like that one best symbol.
Yeah.
We've done great there. And then when you do the whole classification search, that's when it just goes.
It just goes start. Like it just like stop.
Yeah.
I'm wondering with because you're starting to bring in other. Wondering if over time we can have the whole patent prosecution highway for the joke. Like it seems to me that according to that basis, art being cited becomes much more similar across all the
So
do it.
it is. But I will tell you something. You probably heard from examiners that I'm trying very hard to have
Switch over.
yes, yet we have about
Right. So they don't care. Yeah,
so they have primary examiner saying, why didn't you search in 707? I'm like, what the heck
What
is
is
707?
What are you talking about? Yeah.
Yeah, so that's been
Change
the
is hard.
struggle
Change is
with
hard.
training the system.
How many people did we lose after 2013?
Yeah. Yeah.
They were like, oh, I'm not going to learn new stuff.
That's true, man.
Exactly.
Right.
So that's the big challenge.
Yeah.
Training the system, trying to
Right.
get it, but
Yeah, you got it. You're killing me. You can't make everybody happy. I would say, yeah, a lot of sweet. Good. It probably makes it harder for people like you.
For something like this, yeah. Because
yeah, yeah.
And it's right. Like any other union organization, like I'd respect the senior guys because charge.
Exactly. So it's been quite interesting. I think to get there, part of the problem is part of the no one's but you don't know it's not quite carrying on. They're trying to align with
Yeah.
Good job. Enjoyed it?
Oh, this was
a very lively and interesting discussion.
Are you gonna hang around for the graduation or no?
I don't know if I can.
I hope I can. I'm supposed to be flying out tonight.
Oh,
okay. Get to Howard tomorrow for an engagement.
Oh, okay. Yeah, I know. I lived in DC years ago, and it was bad up here in Atlanta.
There.
It does kind
Are
of
you
like take me. I
exhausted?
almost like fell asleep after the session.
Are you tired? You must be so tired. You have so many.
Yeah, it's okay. It's okay.
Yeah, I know.
And I feel like I have like some of my former alumni. They're staying at the house. I feel like I have my college students back home. Like,
Oh,
spring break.
they're staying.
Yeah.
Oh my gosh.
I had to wait up on them to get home. Like,
My God, how late were they out?
At 1 o'clock. I mean, which is not bad, but
It
it's
is
like
bad for us. I go to bed at 10.
It started. So I found out. I thought about a bias. It has to do with color, because I actually get the most compliments on this series, and I think it's because it's pink. Because you don't expect everything. Because this should be a woman's.
Yeah. My husband loves me. My husband loves them. Has loves does this. That's a good one.
That's right. I mean, it's something. It's not as impactful. Okay, everyone. May I have your attention, please? May I have your attention, please? We are about to begin. James, leave Derek alone. All right. Once again, you guys are blessed with having me sit up here for yet another session. So, yay. Happy to do it, though, and happy to have you all in the audience. This is a topic that is pretty much super near and dear to Elaine's heart and my heart. It's why we're here. It's why we push so hard for diversity and the programs that we implement. And so that's what we're going to be talking about today. This is really informal. It's fireside chat. Feel free to ask questions, pipe in at any given point. And so with that, I'll let Elaine introduce herself, and we can take it from there.
Good afternoon. Good to see you all. So many familiar faces and some of our Patent Pathways participants, and also PPP overlap, which is wonderful. My name's Elaine Spector. I'm a partner at Harity and Harity. I joined them about 7 years ago, and what's great about my firm is that from the moment I walked through the door, they've been very diversity focused, and they're innovators themselves, and so they really wanted to solve and put a lot of effort and time into how are we going to diversify our profession. My story is not unlike many others. As a mechanical engineer, I would say in my starting class at University of Maryland, there was 500 students in the class, and I looked around the room and I don't think I really understood that mechanical engineering wasn't that diverse. My dad was a mechanical engineer. We didn't really talk about diversity back then. And I looked around the room and I'm like, 1, 2, 3. Oh my gosh, there are 3 women here. So understanding what that feels like when you are at school, sometimes professors not looking you in the eye, and then entering the patent profession, at first at a small boutique with all white men, and then trying to learn to navigate the field. It isn't easy, but there's a lot of lessons learned along the way. And my hope is that we can remove some of those barriers to others who are entering this field. This conference is about diversity and innovation, and I'm going to repeat what everybody says, how important it is to have lawyers, patent attorneys, agents that people trust. And sometimes that is because we have similar backgrounds. So I'm excited to be here and excited to talk about this topic of retaining diverse talent.
So do you want to start off and just give the crowd some information on, kind of our new partnership, as it were, and how it came to fruition?
Oh my gosh, I don't even remember how it came. I think it came through fruition by just conversations. We decided that our nonprofits were both focused on bringing more diverse talent into the field. And so NCPP has been around through their patent pipeline program and are filling that need for training. Like you said, you can pass the patent bar. I have actually the similar story. I took it 2L year, no experience whatsoever. I actually did claim drafting. I think I was the last year. I'm dating myself. But I had no idea what I was doing when I entered into the profession. So NCPP is filling that wonderful need and recruiting and bringing more diverse talent in. We wanted to step in the area of providing resources for those who want to take and pass the patent bar. So the PLI course our nonprofits will cover, as well as the sitting fees for the patent office. And so we felt like there's a synergy between our two organizations. And right now we are working together with supporting participants. And so we'll refer participants, if I have participants through our program that are interested in getting more of that experience and getting those reps. I mean, learning patent law and drafting applications, it's not a spectator sport. You don't sit in class and say, oh, I got it now, I can write a patent application. No, you got to get reps, you got to get trained. And so NCPP and the Patent Pipeline Program has provided that great resource to participants. And, what we're both trying to deal with is like, how do we get these wonderfully trained, highly intelligent participants jobs? And that has been a struggle for both of us. And at some point I think our first year was super successful and the affirmative action decision hit. And so we're getting more pushback on that. But what was it? I'm gonna throw it back to you.
No, in my mind, it's a match made in heaven, right? Like the two things that law firms are always looking for in this profession is, have you taken the patent bar and do you have any practical experience, right? None of which have anything to do with going to law school. When you really think about it. And so traditionally, we've asked individuals who had interest in patent law, the first thing we tell them is, hey, go to law school, become a patent attorney. Okay, go acquire debt and not learn the skill that you need in order to actually be hired, because firms are going to view you now as having this pay grade. At this juncture, I think one at first years are making 180, 200,000 a year. But you don't have the practical experience to justify that firm to hire you, right? So we've taken a unique kind of approach to it, and working with getting more engineers and scientists the practical application over with the patent pipeline program, and then also passing the patent bar with the patent pathways program, right? And it's a lot of P's floating around, but you get the point. So that's one of the things that I really like about our partnership. And as this class, we have two former patent pathways. The class that's graduating today, we have two former patent pathways or two patent pathways alumni. And then also in your current patent pathways class, you have, I think, is it 2 or 3 patent pipeline program alumni in that class. And so that's a beautiful thing, because we're trying to create the perfect candidate, so to speak, as far as what we've understood most law firms to want, right? But the issue is, as Elaine mentioned, is that it's still not good enough, right? It's okay, they have the patent bar, they have experience, and it's still not good enough, right? Like these are all the excuses that we used to hear. Oh, well, we can't find the diversity, right? We can't find the diversity. Oh, well, they're diverse, but they're not trained. We can't justify the spend. Also, now we have them being trained, they're diverse, we're doing the recruiting, the legwork, where they're taking and passing the patent bar, and it's still not good enough, right? And in the wake of the Supreme Court decision on affirmative action, we've seen our sponsorships take a landslide, right? And it's really, unfortunate to come so far and then, backslide just as quickly. And so with the reduction in DEI efforts across the board, we have to continue continue to ideate and figure out ways to actually help you. And the one thing I can truly appreciate about Elaine is when I'm in my feelings about, you know, something a student has done or something a law firm has done to a student or how they treated them or all these things that we have to deal with, I can call her and it's this kindred relationship because we can relate on all of those things, not only from the perspective of seeing our students go through them, but having gone through them ourselves, right? And that takes a weight off of me because at certain times it feels unbearable. Yeah. It's like who can I talk to who's going to understand exactly what I'm going through and exactly why I feel like what that firm just did was, I'm going to say BS. I'm going to keep it PC and say BS, but you know what I really want to say.
Yeah, it's really interesting because we do deal with a lot of the same problems. So as soon as it's coming out of his mouth, I'm like, oh my gosh, yes, exactly with me. And, you know, it is, we're both passionate about diversity and we want to see, and we're both want to see results. Like we're taking action and we want to see results. And so when we see pushback or we see maybe excuses or reasons why or et cetera, you know, it's disheartening. It's disheartening. So I'm grateful to align with you on these initiatives because I think I still think we need to ideate on it and continue to pivot. And if any of you have been involved with a nonprofit, it is like a startup company. So you plan everything out. This is going to work like this. Everyone's going to pass the patent bar. And we, you know, right here, we're going to introduce them in 3 months. They're going to pass it. And then we're like, oh, well, that didn't work. Okay, pivot. And so you're pivoting a lot and you're innovating and you're trying to find ways because, you know, our field it's a complicated field. It's a complicated profession. And so, you know, we don't give up. There's definitely still progress to be made in this area.
Yeah, yeah. And with that, we're always open to ideas, right? Like it's an ever evolving society and profession. We've had to evolve and adapt and change with the times. You know, as recently as you, I guess, expanding the doors for the Patent Pathways program. Um, and that's our goal, and that's I think you said, you know, it's what we're passionate about, right? And that resonates because it's definitely not the pay. I don't. We're not making, you know, the money off of NCPP and the patent pipeline and the patent pathways program. It's
volunteer.
Yeah, it's volunteer.
Volunteer.
And to put it into perspective, right? When we look at the people who've trained with us before, you have Greg Kirsch's, Kobe Henry's, Keen DeCarlo. I think James has done. Like we've had a bunch of people over the years who've done sessions for a patent institute training or a patent pipeline program, and these are patent attorneys with six-figure salaries and doing phenomenally well on their own, right? There is nothing that we as a nonprofit organization can pay them to compensate them for their time or to compensate them equivalently for what they could go out and draft a patent, you know, in that same time and do, or go out and draft the office action. So it's very important for the next generation of students and individuals in these programs to understand that it's free, but there's a lot of work and a lot of commitment and passion and devotion that everybody who is associated with these programs are putting in. And that can't go without, you know, we can't lose that. We can't lose that sight. It takes individuals like yourselves who are sitting in here who's going to say, well, I'm going to step up and, you know, help out where I can. Mentorship, development. One of the things we're seeing is just professionalism, right? It's like we can teach you how to draft claims, but we can't teach you how to be professional, or we don't have the bandwidth to teach you all the little intricacies to professionalism. Would you like to give some light on that in your program, Elaine?
Yeah. No, we actually started a soft skills sessions within our Patent Pathways program because I remember what it's like. Because I'm first generation American, first generation lawyer in my family, and I remember my first job walking into this law firm and thinking, what is this? And so I had to make many mistakes to learn kind of what this law firm life was all about. And so, but I had gone to law school, so at least I had kind of some basis. Some of our Patent Pathways participants are straight out of engineering school. they've had zero exposure to law or to law firms. And so they really, first of all, the culture within the law firm is something they have to adjust to. But a lot of it, some of these sessions are about what does it take to be a trusted advisor? We brought in Stuart Hirsch, who teaches this program. Like, what does it take to be a trusted advisor? We have this trust equation, and we go through it with our participants. And really, to our partners that we support, when you're working within a law firm, how do you gain their trust? What are kind of these some of these unspoken rules within law firms that you might want to know? Trying to teach our participants that will give them a leg up. So we've just started implementing that program to help them navigate within the law firms, because we're finding that that's a big issue with regard to retention. They finally get a job, and then within 6 months to a year, the work dries up. And then we can talk about, I mean, this is a whole nother topic about why are, and this is standard, I don't want to be too judgy with other law firms, but why, and I've been there, why are new practitioners looking for work their first year? That's tough. I mean, you're new to the law firm and the culture, and we're asking them to go seek their own work. That's hard. So there are types of practices that law firms can really be more open about and potentially changing, so that maybe, distribution of work will change. And I know that can also be with regard to advancement. Are you getting good projects? I know there are some firms that have implemented systems that distribute work more equitably. So these are some things that have affected retention. I don't know if you've had similar issues with regard to your participants about, a year into it, all of a sudden we're trying to find them a new position.
I can't say that I've had some manners, right? I think the bigger issue for me is this expectation that these students are, how can I put this, further along in their legal career than they really are, right? Like, we have firms treating technical specialists right out of undergrad perhaps, or graduate degree, first time in the field, understand that we're training them drafting and prosecution, and yet their expectation of these individuals is that of, I wouldn't even say a 1L, it's more like a first year associate. Carry yourself in this way, billable hours, this and that, you should have done this, you needed this. And that's all fine and well, but you realize that, like, with this program or these programs, and with you getting a more junior or novice person who's green, there's a certain level of mentorship and development that you as the firm still have to carry. And I think some firms get it confused and think, oh, well, yeah, they know how to do the work, they're good, and we expect all these things. And so a part of my job is I've come as a recent to realize is actually leveling the expectations of some of these firms who have expectations of our candidates that are far and above actually what they really should. We had a Black female student drop the program last year because she was working with 3 different attorneys at the same time as a technical specialist. I don't think I worked with 3 different attorneys at the same time my whole private practice career. And had I known that, I would have stepped in, but it's one of those things that wasn't brought to my attention until later. And so I deal with those types of issues, and that's been challenging for me, because also the firm is a business, right? And I understand, okay, so what a first year associate today, what do they make? I'm asking the audience, what does a first year associate make today? Average, 210, all right? Technical specialists, 100,000, right? So if I can give you somebody who can draft and prosecute patent applications as a technical specialist who hasn't gone to law school, and then you have a law grad making 210, which for the most part probably still won't have the same amount of experience as this technical specialist, why are you expecting them to carry themselves in the manner of a first year or a law student, who's recently graduated? When indeed, there's a $100,000 differential in those 2 individuals. So you can take that $100,000 and invest some money in their training and education for professionalism. it's not a one-stop shop. And especially when it comes to underrepresented minorities who haven't traditionally had the upbringings, like who haven't traditionally had like a father to tie their tie, to show them how to tie a tie, like, you know, looking individuals in the eye, firm handshake, you know, making sure that you're clean cut and, you know, up to par, up to speed. All of us don't have these things. All of us didn't grow up with these. We're figuring them out on our own, right? And so the expectation level from law firms, it has to be level because it's already ridiculous in my opinion. But it just has to be leveled some way for the actual diversity to thrive.
Yeah, I agree. I agree. Yeah, there's a book that I read called Executive Presence that talks about how you appear, like how can you, you know, as a first year, they say, well, how should I dress? What should I wear? Should I be conservative? Well, I think when I started, I was as conservative as I could be. I did not want to draw any attention to myself. And as you've gotten older, you know, you can bring out some of your authentic self. But that was a good book if anyone's looking into how to navigate that culture in an executive setting, or even for those who are just getting involved.
And so we've talked some about just the challenges that we experience and that we've seen in law firms. You know, one of the things that you and I have discussed is it's one thing to present a qualified candidate with a firm, put them on to a firm, put them on that trajectory, they get hired, and they're going throughout the, you know, the process and learning and developing. But what about retention? Right? We talk about, you know, getting the job and, you know, bringing them to the table, but what are you seeing as far as you know, retention when it comes to what's occurring with law firms?
I wish I could say the stats were good, but they haven't been. And actually, one of our longest hired participants from our 2022 class, you know, just hearing that things are there might not be a future at her future firm. And I think that the concerning part is, and this could be again the expectations that firms have with regard to the learning curve. There's a steep learning curve with patent law. I mean, on average, it takes 1 to 2 years, probably 2 years. That's probably a better estimate of getting up to speed on drafting complex technologies and prosecuting them and all the nuances that go in a profession. So it is disconcerting when after a year a firm might say, well, they're not getting their billable hours. They do good work. The work is really good, but they're not efficient. And usually we hear that conversation after a decision has been made. And so we're like, well, we can work with them. Like, we'll work with them. John Harry will raise his hand and say, I will teach them about efficiencies. We're all about efficiencies at our firm. But usually that decision is made after the fact. So they've reached out to us, too late in the process. So we're trying to intervene earlier and having some check-ins to make sure our participants are performing well. But even then, they might be doing well at that time, and then 3 months later, they're not. And it's almost like, I don't know if you liken to this, but my daughter plays volleyball, and she's a senior in high school. And she played a lot her sophomore year, and they have a new coach senior year, and she didn't catch the new coach's eye. So she's been sitting on the bench a lot. And it's almost like that, I would say, in our patent practice, that if someone sees something in you, then you can almost, it's a bias. You can almost do no wrong. And they'll take you under your wing, build your confidence, and you're going to perform better. I know that happened to me when I was in high school. I had a 10th grade teacher that was the most loving, amazing woman. When I was underperforming, she said, you're going to do better. That's all it took. And so, what firms can do, we talked a lot about mentorship and sponsorship, is taking this diverse participant who's probably shell-shocked by this law firm and nurturing them, giving them some confidence to say, you can do this, and not be, see one thing that you don't like and then say, oh, we're out. Like, and they're not meeting, I understand it's a business and we have to make sure that we're we're generating profit because we're a business. But really, are you losing that much on this participant? I mean, if you make the investment, how much more will this person give back to you? So those are kind of our thoughts, like earlier intervention and giving us the knowledge so we can come around them and support them. So the better support system you have, the better that person's going to perform. And sometimes it could be a confidence issue.
Yep, yep. I would definitely echo the, letting us know when things are going on early on in the process when you see them, so that we can help support those students. We don't view this as kind of a one-time ordeal. Like, we still support students far and beyond like the program, right? There are people who are there are people who I've trained years ago and they still call me for advice. They still call Kobe for advice, Keen, Greg. Um, we're in a small profession, right? So we have to be able to support each other. So I say that to say that if there are our students with your firms, it's not like we just hand them off and walk away. That's never the case. We want to build in as much support as we can, but we can only provide that support if we know there's an issue, right? And we've seen it happen when decisions were made, for candidates, that didn't work out, and we had no idea about it until the end. We could have possibly intervened. It's just like the case I mentioned earlier, where a young lady left the program because she didn't feel supported and she didn't see people who looked like her. And by the time it got out of hand, by the time she got fed up with it, like it was too late. Now that's from the student side, but we've seen the same thing happen from the partner side. It's, oh well, we are, it's too far and we're good. Well, give us the opportunity to address those scenarios or situations and see what we can do to help, right? Help mitigate. Because all too often, we're all predispositioned to biases, right? Like, I'll tell you that I have several seersuckers, as you guys have seen, and the one I get the most compliments on is this one, right? And would anybody like to give a reason as to why they think I get the most compliments on this seersucker? Not material. Hold on, I think I heard it. The color. What about the color? What do you expect a man to wear? Typical society doesn't. Pink is a woman's color, right? But that's how we're groomed. Blue is for baby boys, pink is for baby girls, right? So I say that to say that we all have inherent biases. Doesn't make them necessarily wrong all the time, but a lot of times they can play into our decision making, right? And we all have to be honest with ourselves and say, yes, I do have biases. Each and every one of us has some type of biases. The dig comes in is when you realize that your biases are impacting others, or you're letting those biases unfairly impact others, right? So with some people, view African Americans as predisposed to failure, right? So when they're given that chance, we're going to give them a chance and try them out, right? And when one thing goes wrong, we didn't expect it to work out anyways. We knew it wasn't going to work from the jump. And Margot Bagley sent me an article, with the recent Michelle Obama speech, and we're not allowed to fail upward, right? So when we have that issue, and it happens with women as well, when we have that one issue, right? I can remember it at my firm, one issue, right? You thought I was the worst person in the world after several years, and we have that issue, and you come down on us like thunder, right? Rain down on us like thunder. We're horrible, right? But if our, lack of a better term, we'll just say white male, if a white male does it, well, he had a bad day, right? Or a male in general, you know.
Well, we have our minority firm incubator at Harity, and a lot of our firms would say that exactly. They said, we can't make a mistake. We make one mistake and we're done. That's it. So, it's those biases. It's like they've decided that beforehand. They're looking for one mistake, and that's all too common. You would think that it wouldn't be, but it's all too common. It still happens.
here's what I've seen. Now, don't necessarily agree with it, but here's what I've seen. Our program is open to all. If you're an engineer and we can train you to get into the profession, then or scientist, right? Then you're a viable candidate by that means. But if you're older, let's say, I don't know, 40s, 50s and above, maybe even 30s, some law firms look at your lifespan, like they're looking at you as a profit center, right? Well, this person is only really going to be able to practice with us for this amount of time, and it's actually held against you. It's a bias, right? It's a bias, and that's what you deal with.
Ageism.
Ageism. Yeah.
Yeah. Yeah.
You speak up, King. Here's the other piece to that too, though, especially in today's economy. I've seen this where we've had a great candidate on paper. They're probably 3 or 4 years outside of undergrad or a graduate degree. They've been working, so they have experience. And you look at that and you say, okay, well, they have experience, which means they probably have some level of professionalism. And that's what we want as a law firm, right? You want to be able to transition those individuals as the technical specialists and patent agents. Where it gets really difficult now is what I'm seeing is that sometimes in those tech positions, 3, 4 years, let's say working for Google, Meta, whoever, these candidates are already making well and far above what the law firm is willing to pay them as a technical specialist. So I literally had the most perfect candidate, a young lady, tell me, well, I'd have to take a $20,000 pay cut and stocks and options and bonuses. Like, why would I do that? I want to do this, but financially, it doesn't make sense. So there's also an issue where law firms aren't paying for the type of talent that they actually really want to recruit.
That's exactly right. Yeah. And we actually accept career engineers into our program, anyone facing barriers entering into the patent profession. And yeah, that can be a problem for those who have retired. Obviously, they're looking for something new. But for those, like you said, that have been making a nice living and short term would have to take a cut. That's a tough pill to swallow. And like Braxton said, firms are usually they can make money off of a technical specialist, as Keen said as well, because their salaries aren't as high as a starting associate who's doing just prep and pros. So it's kind of that trade-off. But yeah, our program absolutely will hire, but we run into that same problem with salaries. And it differs among big law. We have smaller firms. And this is really interesting because we're trying to think of a way to get the reps and still keep their full-time jobs. And are there opportunities to do part-time work or internships or corporations stepping up to help with some training? Brax and I are not going to solve the diversity problem. We can't. But it takes our entire field to step in and do the work, to train, to volunteer time, to mentor corporations. I know you don't hire freshly out of school, but you guys are pretty talented. So you could help too. So all of us, whether you have time to train or whether you want to volunteer as a mentor, everyone can do a small part in advancing diversity. It's as easy as that. And if anyone's going to IPO, we're talking about this on Sunday for a networking lunch called Making Room for Diversity in Association with ADAPT. So I hope that if you're going to IPO, you can attend that on Sunday morning at 11:30.
James.
Yeah. You know, it's so funny because we've done, it's paper after paper. We've written white papers at IPO about this topic. We've got the studies, we got the information, et cetera. John Harity likes to joke, when I joined Harity and Harity in 2017, they had one diverse male and 13 white men, and then they hired me. And and then we started these diversity initiatives. And let me tell you, we have grown to about 45 practitioners now in 7 years. So he says, our firm changed when you came. Do I think it's because of me? I don't think so. I'm like, that's ridiculous. But it's because we are now bringing more diversity. So our firm is the living proof that having a diverse workforce improved the bottom line by a lot. And so, yeah, I don't know where the disconnect is. Where's the disconnect? If you can answer that, then we're done. Drop the mic.
Yes.
Yeah. 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 Yeah, it's interesting because our trusted advisor talks about that, about like, if you're going to be late for assignment, you need to communicate it. It talks about all the things that go into being a trusted advisor. It's a wonderful class, but it doesn't end there. You're exactly right. I think the hard part for us, because Patent Pathways started within Harity, that it's hard for us to tell another law firm how to run their law firm. And so you know, it's a gentle, you have to be super careful on how you're doing that. We did have a webinar about inclusion once they've hired a participant. How do you make sure that they're trained? And how do you make sure that they're included, and steps to do that? And now we are engaging our law firms on one-on-one conversations, but that's a great point. I think this subject about what the level setting is, what their expectations are, I think those are wonderful conversations to have.
I agree. I agree. I think it needs to happen more. And I'll say that, even with, the patent pipeline program, it hasn't happened to the extent that we would like it, right? Part of that is purely being resource constrained, right? Um, am I making excuses for it? No, there's always more room to be, there's always more work to be done and improvement to be made, but we are resource constrained. And when we devote so much to the students and attention to them, attention to the law firms themselves can kind of fall off. But I will say, as far as, professionalism, when we see things in class that give us pause, we bring those things to the students' attention. And we have kicked students out of the program. So this class that is graduating today is not the class that we started with. If you are not turning in your assignments as a PPP student, I'm going to assume you're not going to turn in your assignments at a firm. And I don't want to put our name and reputation on the line in backing individuals we don't believe are going to do the work. And so we have had to, unfortunately, kick students out of the class or give them alternative options if they are truly interested in continuing on in developing and learning, but sometimes on their own dime. If this is really what you want, well, then you need to have a bigger stake in what's going on. And so some of these are learned lessons over the years. We're continuing to adapt and grow and implement them. But also to Elaine's point earlier, different firms have different structures, smaller firms, medium-sized firms, larger firms. Um, there's a whole lot of just variability in that just in general, right? But we're always open to feedback. And I hear you, Rita, loud and clear. We're always open to feedback and leveraging that and improving the program, because if we don't do that, then we're not putting our students giving them the best opportunity to succeed. And at the end of the day, we don't want a sour relationship with the firm, right? We want the firm to be happy, we want the students to be happy, and we all want to succeed together. And so we try to put our finger on the pulse of those things when it happens, but sometimes it just doesn't work out. Could you speak? I can't hear you. Could you speak up? Yes. Yes.
Yeah.
Yep. Yep.
Yeah, we've talked about that.
We we have. I am. I don't know if they have a professionalism kind of course. I mean, we need professionalism 101, like at its core level. And if that's what that organization have, Rita, let's definitely connect and provide that, because we're so focused dialed in on executing on the substantive. This is how you do the job. This is how you do the job. This is how you get it done. We just don't have the resources to then continue to devote towards more of the professionalism, even though we have, a couple professionalism hours here and there for the students. Yeah. And same with you. It's like your focus is on getting them trained to take the patent bar. It's professionalism isn't our niche, even though we know they need it. So we're open to any opportunities and thoughts and ideas that you guys have in order to help build that, because it's something that they need. And I might sound old by saying it, but this new generation is not like us.
No
Not like
offense.
us.
No offense to you all that are here. I've got some in the next generation. No offense. The generation.
I had somebody self-select themselves out of the program because they said writing a 500-word essay and submitting a resume and transcript was too much not to be guaranteed a job at the end.
Oh.
I said, well, you'll never come through this program. I might need to pass that name along to you. Yeah, I think somebody had a question, maybe. Yes.
So I would say for the Patent Pathways program, we recruit also law students. So they're sometimes hiring people that have a law degree. So that's not, it will vary because they'll have to offer something more to someone who has a law degree. So that hasn't really been an issue. When we first started Patent Pathways, when we were reaching out to firms, we tried to obtain information about the firm beforehand, and there were some that we just crossed off the list. We wanted to approach firms that had technical specialist training programs so that they weren't guaranteed someone that they didn't have to train. So they had at least the tools to do that. Now we've learned through work with some firms that they just were not equipped to take care of our participants, and where we didn't pursue the partnership after that because we're like, there's just no way. But again, it's very nuanced too, because it can all sound wonderful on both sides. And until that participant enters into that law firm, I don't think I really understood all the differences between the law firms and how that they're run. I've worked with quite a few, but I'm gaining more knowledge about how some firms have very good aspects for integrating and including new participants, and some of them are really, quite frankly, just not that great. So
yeah, it's difficult too. And we talked earlier about the panel session about like, only having like, let's say, one perspective maybe when it comes to AI, and having various perspectives to give the feedback. I think we could be in some ways, narrowly focused, right? Like you've had your law firm experience. You know what training should look like or could look like. I've had mine similarly, but that doesn't mean that the entire ecosystem operates that way, no. Right? And so to answer your question, I say it could definitely be better. I'd welcome any thoughts on how to structure something where you're kind of vetting the firms as well, because the other portion of it is, well, in the scenario where something doesn't fit the check off all the marks as we want them to, and even with our current program, which is that they have a client sponsor to help hold them accountable, so we don't see some of the nefarious things or horrible things we've seen happen with law firms and underrepresented individuals. Are we willing to potentially hold up a job for another person that could actually get in and do well and walk away, or are we willing to kind of roll the dice on it somewhat, right? You're coming to me and say, hey, we have this position open, and we want to partner with you, and great. Maybe you don't hit all the criteria, but we're like, well, that's one more spot we could use to get somebody in. It might work. How can we, work around that? And so that's really where, because those opportunities don't come along all the time. And as you'll see here with this class, not all of these students who are graduating have offers in the bag as we've had with our previous classes. Our job is to prepare them such that when they're prepared, when they have that opportunity, and we're struggling and we're continuing to try and do that, but that opportunity doesn't always present itself. And sometimes you get your foot in the door, you get your 2 years experience, you realize it's not the firm for you. Well, you know what? If it's not working, I'm gonna support you to go someplace else, right? Because being in that, working for a firm that's not working for you and where you feel like shit, treated like shit, it's horrible. It is a very horrible and lonely feeling, like being on the island. And so, what's that? What's that? Yeah. So yeah, it's that, it's that angst, right? Am I going to hold it? And I've had this happen because this firm did not fit my criteria as I lined out. Am I willing to hold up a job for a potential diverse candidate?
yeah. Well, I love that you have corporations involved. I mean, we have some of our Patent Pathways participants that one of our corporate sponsors actually encouraged one of their law firms to join the program. And when they hired someone from the program, when she was a summer associate intern, they took her out with their general counsel to lunch. And so I just love that inclusion and that access and that support from the corporate side. So I see that as the ideal situation where we have a corporate sponsor and our participant and our law firm kind of all together Yeah, you haven't had this.
No. It works well and it makes sense, but the sad reality of it is that we are moving away from that after the Supreme Court case. We don't see the same level of corporate, um, of corporate participation in order to increase diversity. Everybody's scared, right? Um, and it's a shame. And so we're looking for alternative ways. Okay, I'm getting the time. Got my soapbox. Well, we're looking for alternative ways to deal with it. Be happy to talk to you any about that offline. Do you have any parting last words?
This is, I will say it again. We encourage everyone to just do these small things that can, and this is kind of ADAPT's new, small actions make big changes. So did I get that right, Mike Benz? You can be a hero. I'm gonna say that for them. But there's a lot of opportunities between our two organizations. Patent Pathways, we have committees, and you can work on a committee. It's a great way to meet other in-house counsel or law firm members who are passionate about diversity. And it's fun coming here because I see so many people that I've met over the years and people who are interested in diversity, and it's such a wonderful group of people. So get involved if you can, even if you have a little bit of time. ADAPT can help place you somewhere. It's a worthy cause, and it's what makes me excited every day.
We're always looking for help. We can't do it alone. We need you guys. Thank you.
Yeah, thank you.
Everyone, we will have a short break before our final plenary panel that will start at 4:30. 4:25.
Yeah, let me pull it out. Yeah. I mean, it was basically like, what have we learned? What's the first question? I took notes when we talked, so I'll try to frame it a little bit. Yeah, it's all the same. The upstairs panel just let out. That's why I'm here now. So I'm not, you know, a couple minutes. Yeah, go. So, Keith, are you associate dean? Yes. Yeah. Introduce you properly. Yes. Research dean? Yeah. Congrats. Thank you. Did you just start this year? No, so this is my second year. Okay. What's that?
You have what you need?
We have everything. Yeah. I
Okay.
think my only question is, what do you want to do timing wise? I know we're a little bit behind.
What do you think? I mean, are you guys think you can wrap on time?
What time
Or-
did we?
I think it's 5:30 or 5. No, 5.
So we're supposed to start at 4:20.
Oh, sorry. Okay, so we're 10 minutes behind.
Yeah.
So 5:05. Do you want to try to stay on time, or I don't know. Do you feel like you can, or do you want to take 5 extra minutes?
We take 5 minutes.
Okay.
Is that all right?
Yeah. 5:10.
Yeah.
Okay. And do you want to just hold forth, or do you want me to introduce you, or?
Oh no, I can do all of it. Yeah, just whenever you're ready to call everyone to order.
Yeah, we've asked people to come in. I think they can get going.
Okay, yeah, go ahead and ask people to come in and we'll start in a minute. Okay.
We don't have any like slides or anything.
No, this is fine. Yeah.
Okay, I just want to make sure.
Yeah, we're good.
All right, thank you, man.
Yeah.
Good luck, man.
Thanks, dude. Should we begin? Okay. All right. Welcome everybody. We'll get started. So welcome. Thanks everybody. Welcome for sticking it out for this, the closing plenary session, which we've titled Diversity and Innovation, what we've learned, what we need to know, and where we're headed. I'll be your moderator for the session. My name is Paul Gugliuzza. I'm a professor at Temple Law School in Philadelphia. And the goal of this panel is we thought we'd conclude the conference by trying to bring together real thought leaders from the corporate world, from private law practice, from academia, and from government to assess both where we stand right now with respect to promoting diversity and innovation, and also talk about what we ought to do over the next 5 to 10 years, particularly in terms of data collection, data analysis, experiments, and even pilots. So let me start off by introducing our panelists. And I'll start here to my immediate right. This is Cassie Helm. She is a partner at the Deckert Law Firm in New York City. Next to her is Keith Robinson. He's the Associate Dean for Research and a Professor of Law at Wake Forest University Law School. After him is Lisa Nguyen. She's a partner at Paul Hastings in Palo Alto. And then going further down the line, Farhina Rashid. She's Deputy General Counsel and the Solicitor of the United States Patent and Trademark Office. And then lastly, at the very end there, Danielle Coleman, who is Senior Associate General Counsel at VMware by Broadcom. So what our plan is to structure our discussion around two big questions that I alluded to a minute ago. First, what have we as IP professionals learned about diversity and inclusion and innovation? And then second, what more do we need to know, or what sort of things do we need to try? And we'll hear from all of our panelists on each of those questions, and we will try to hit our scheduled end time at 5:05 p.m. As close to on the nose as we can. So let's start with the first question, and I'll start right here to my immediate right with Cassie. What have we learned about diversity and innovation over the last 5 to 10 years that I think this has been a topic that's been part of the broader consciousness?
Okay, so.
Yes, microphone, sorry.
Oh, can you guys hear me? Okay, is this on?